Someone make it make sense.
Probably a couple.
Howdy, 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 squirrel people of the world. How are you guys doing? You might be like, wait, what is this? This isn't Shanna. This isn't Mario. This isn't a document. No, we have a special treat to start this one off as a surprise. A special surprise, we shall say, in honor of the special master who has been referenced so far many times in this Shanna Gardner case, and we will hear even more of. Special master who's going to be enlisted to help review some of the potential attorney-client privilege materials. And that reminded me of something very, very special that some of you guys may have seen, some of you may not have. Regardless, this is a real treat. And this is a deposition from, as you can see, this is March 2018. We're going to hear a good bit about the special master. So let's enjoy this train wreck deposition.
We are on the record at 9:16. Today is March 12, 2018. This is the video testimony of Robert Baez, taker in the matter of Justin Marquez versus Daniel et al. Case number 17 CV 30522.
This is so good.
District Court for the City and County of Denver, Colorado. Today we're located at 110 16th Street. Suite 1400 in Denver. I am the videographer, Timothy Auermeyer. The court recorder is Benign Basinger. Will all attorneys please introduce themselves, beginning with the plaintiffs?
Thomas Werge on behalf of plaintiff Justin Moskowitz.
Attorney Robert Abrams, license 37950, appearing pro se.
Neil Sullenberger, attorney registration 48698 for the firm.
Will the court reporter please swear in the deponent?
Attorney, next, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
Thank you.
Good morning, Mr. Abrams.
90s style sunglasses there. Love it.
As you know, my name's Tom Werge. I'm counsel for plaintiff Justin Moskowitz in this lawsuit. And do you understand why you've been asked to give your deposition today?
No.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
And are you aware that you are a witness regarding the actions of Abrams and Associates?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
Mr. Abrams, have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master.
We're going off the record.
No, we're staying on the record, please.
They didn't make it to like 2 minutes in. Oh my God.
Would you be prepared to read back my answer to the special master regarding counsel's questions as to whether or not I answered that question?
Oh my God. Like this contention, the point of contention here is over the question of just, do you know if you've been deposed before, how many times? Incredible. Dialing special master.
Good morning. Could we speak with David Tenner, please?
Let me check and see if he's in. May I ask the caller?
Thank you. Yes, these are the parties from the Moskowitz versus Dahlman matter, and we are in the middle of a deposition this morning.
What is he doing?
Okay, hold on just a moment.
Thank you.
I wonder if the special master is like, oh no, not them. I'm telling them I'm not available.
He is not in the office at the moment. Can I get a number and have him call you back?
Yes, that would be great. If you could please,
Okay, I'll send him an email right now.
appreciate it.
You're welcome.
Bye-bye.
They're on their own. They have no supervisor. These children have no chaperone to help them.
We should
Mr.
stay on the
Abrams.
record here.
No adult supervision.
Yeah, we're still.
Oh, okay.
Yeah. Mr. Abrams, I want to ask you one more time. Have you had your deposition taken before?
Object to form.
Asked and answered, move on.
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams,
Okay.
this is not your
Please
deposition.
don't harass me.
No, I'm not harassing
We're gonna move
you.
for sanctions
I'm
against
asking
you.
you to.
If you're
to
not
answer
going
the
to
question.
allow
He just
her-
answered the question.
He did not answer the question.
He just said he did not recall. That's an answer to the question.
So it's your testimony under oath today, Mr. Abrams, that you do not recall whether or not you've ever been deposed before.
Asked and answered. And so please read
You
my
need
answer
to
back.
answer my questions, Mr. Abrams.
Please read the answer back.
No, do not read the answer back, Mr.
Like-
Abrams.
like the
This
answer
is-
to be read
Let's
back.
move on. How many times have you been named in a lawsuit in your individual capacity?
There you
I
go.
can't recall.
Have you ever been named in a lawsuit in your individual capacity?
Yes, he does. That's why it's so funny. There is an attorney. That's why it's so funny when he's like, I'm here pro se. I think they actually argue about that at some point, of course, because the attorney for the firm is there. And yeah, so that's funny.
I think so.
And my take on this is that the reason he wants to say pro se is because he can also object. It's so funny because you'll hear the attorneys objecting, and ostensibly one of them is going to be his because we can't see them, but he wants to be able to object to his own to the questions being asked of him, and so I think that's why he comes in and says he's pro se even though he has counsel there.
Okay. And when do you think that you were added as a defendant to a lawsuit in your individual capacity?
It may have been, if I get it right, it may have been in the BB matter.
Like, it's just so funny. It's like, okay, so then that's a yes.
So it's your testimony today. You've been added. You were a defendant in a lawsuit in one matter, and that was the BB matter. Is that
Object to
correct?
form.
I think they added me as an individual defendant, and they lost the case that went to jury trial. I think that's my recollection. I don't remember it very well. The man, BB, attacked me in a stairwell and
Objection
in
on
my
the
garage,
sponsor.
and I think he named me individually in that
Objection,
suit,
no
and then he
question.
lost that suit. That's my recollection.
Let me ask the question again, Mr. Abrams. Is this BB matter that you're referring to the only time you remember being added as a defendant in a lawsuit?
Object to form.
To my recollection, yes, that's my answer.
And you said the other party was named BB?
Yes,
Okay. What was the other party's full name?
Sean Beeson, we call him BB. I represented him in a matter where him and his wife were both arrested for DUI. He was thrown in a drunk tank for being belligerent, and he sued the city. And then I put a restraining order on him for 9 months for attacking me in a stairwell.
Right.
And then he
Stairwell.
sued, I can't remember if he sued me individually, but I think he did. And then he lost that suit outright at jury verdict. So we're going to move to strike that as irrelevant.
You have to give all that information. This just kills me. Also, he really wanted somebody to know that because he said it twice, that there was a jury verdict on that one, right? But then he wants to move to strike it.
Object to form, and that it's going to lead to non-discoverable evidence under the rules of evidence.
Mr. Abrams, you are
You
not
can't
allowed
interrupt
to.
me.
I am allowed to
He's-
interrupt you. This is my
he's giving his
deposition
answer.
today,
You can't,
sir.
it's my
And
answer. This is my answer.
you are not allowed to put objections on the record. You are a witness today. And Mr. Abrams, you are represented by counsel. Your counsel is allowed to put objections on the record. You are not today.
I am a
Do you
lawyer.
understand that?
I am a lawyer. I don't need a lecture from you who doesn't understand the rules of evidence.
Oh, boy.
Under the rules of evidence, the only thing that can come in under the rules of evidence is truthfulness and untruthfulness. So to the extent that you're trying to disparage me because you have me on videotape and embarrass me for things that you can't bring in, I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you
Objective form.
for continuing to obstruct and not answer any of my questions.
Objective
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're gonna move for
I'm pretty
30D3
We're
sections.
going to move for harassment sanctions against you right now.
I'm pretty sure the unblemished part is not true. I've looked him up before, and I'm pretty sure he has an extensive history of blemishes.
Okay, you're laughing at us with the videotape that you published on the internet about you and your rock band, and you're going to be laughing at me.
What is happening?
And you moved for sanctions and had them denied every single time in this matter, and the
I
jury.
want to know more about the rock band, though.
You see that too. Every single one has led to no sanction,
Mr. Abrams, are
including
you
the last
aware?
one where we quashed all of your subpoenas. And you asked for attorney's fees and you got no sanction.
Mr. Abrams,
Let's move on. Do you have a question for me? You sued my firm belligerently under the abuse of your law license, where we countersued you. We have a counterclaim against you for abuse of process for misusing your law license. You sued me for fraud, civil conspiracy, not civil conspiracy, which is a criminal act. So you did that wrong. And aiding and abetting, which is a criminal act. So you did that wrong. Ask me questions about that or I'm leaving.
Oh, boy.
Mr. Abrams, we're going to be here for a long time today if you do not answer my questions. I just want to let you know that right now
Object to form.
and put that on the record. Mr. Sullenberger, I'm sorry.
Stop laughing at my
Yes,
lawyer.
This is bizarre.
Stop laughing at my
Bizarre.
lawyer and stop harassing us.
Listen,
You
let's
brought us down here for fraud. Ask us fraud questions.
Mr. Abrams, how many times has your firm been added as a defendant in any lawsuit?
As I can recall, one in the BB matter.
So the BB matter and then this matter as well? Those are the only two times you recall that your firm has been added as a defendant?
Yes, as I recall.
Aside from traffic tickets, have you ever been named in a criminal action?
Objective form.
Objective form and privilege. So I assert privilege and need not answer.
What privilege are you asserting, sir?
Attorney-client privilege, and
With himself, I think, is what he's going for.
we would, under the law, I need not answer that.
What law are you referring to, Mr. Abrams?
I need a law book. It's, and I moved to strike, and I moved for, I moved to strike the question. I refused to answer under privilege, and I moved for a protective order on the question. So certify the question and move on.
You've again not answered my questions. You've made a absolutely baseless assertion of privilege. Are you aware that in a deposition, the proper objections that your lawyer are allowed to make are as to form and as to foundation? If there is a matter that's privileged and your lawyer objects to it on the basis of privilege, he can instruct you not to answer. Otherwise, you need to answer all of the questions that I give to you today. Do you understand that, Mr. Abrams?
He's raising an objection to privilege.
There's a pending question. Could you please read it back?
What law are you referring to, Mr. Abrams?
Yes.
We can go back.
And this is when he starts clapping.
Aside from traffic tickets, have you ever been named in a criminal action?
Why he has 2 different copies is beyond me.
So, objection, privilege, move on.
You are not answering the question today. You're
Object
refusing
to
to
form,
answer it,
object
Mr.
to
Abrams.
privilege,
Move on.
move on.
It's the answer. Objection,
Move on,
privilege,
move on,
move on.
Move on, move on, move on, move on.
What privilege are you asserting today, Mr. Sullenberger?
Attorney-client privilege. He's already answered the question.
So Mr. Abrams is saying he has an attorney-client privilege over himself being named as a criminal defendant.
Pro se.
Yes.
And the question's intended to harass and annoy. And under 30D3, again, we're going to move for sanctions for repeated conduct like this.
I can't even get through my initial questions here
That's
because
your-
you are being so obstructionist
That's
today.
because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You
No,
have nothing. You have nothing.
Mr.
Put
Abrams,
something in
are
front
you
of me.
aware that Judge Stars already ruled that there is substantial evidence against your firm that you committed fraud?
Object to form.
For misrepresentation of the
Are you
evidence,
aware?
mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full. Do you have a fraud question for me?
Please answer the question.
He just
again.
got asked
I
and
did.
Are you
We're
aware?
Yes, I'm aware. Move on.
Move on, move on. Come on.
Mr. Abrams, have you ever been arrested?
Object to form and privilege, attorney-client.
That's it.
And you're instructing your client not to answer that question on the basis of attorney-client privilege, Mr. Sullenberger.
It's my understanding that Mr. Abrams had an attorney for any issues that may have arisen, and therefore he can assert.
I also don't recall being
What-
arrested.
What part of my question asked for any attorney-client privilege?
He's not being deposed.
I don't have to, I objected. I
We're not gonna
objected to
ask you
form. I objected for privilege for Mr. Abrams.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions
Clear that
today,
you're harassing
and
us.
you are refusing to answer
We've
any
answered
questions
every
today.
question, read every question back.
Yeah, you have not.
We disagree.
Okay, let's ask a couple more questions.
Oh, here
Mr.
we go.
Abrams, what are the pills that you just took?
Object to
None
form.
of your business. None of
Privilege.
What are those other pills?
Object to form,
None of your
object
business.
to privilege.
None of your business.
Medical privilege. Don't
Mr. Abrams, are you under any any drugs today? Have you taken any drugs before you came to this deposition today?
No.
Okay. Have you taken any alcohol before you came to this deposition today?
No.
Any medication whatsoever?
No.
No. Just these pills that
You know
you're
what's funny? He's nodding yes every time he's saying no.
taking here
Yes.
that you are refusing to answer what they are.
Yes.
Medical
None of your
privilege.
business.
Mhm. Okay.
But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object
I
to
don't recall
form.
that.
You don't recall that? Okay. Well, we have a couple witnesses to that, including Mr. Sullenberger. In any event,
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
Oh dear. That's a lot of pills, by the way.
Mr. Abrams, do you recall the motion to quash the subpoena for your testimony
Yes.
that you filed? And you attempted to quash the subpoena to disallow your deposition to be taken, correct?
Object to form.
I don't recall that. I remember we successfully quashed your bad faith depositions. You moved for attorney's fees and you were denied by the special master. That's my recollection, that he found them, that he found them when we told you I would be out of town to, in bad faith, then schedule the deposition to pull me out of my vacation. He found that to be objectionable and he commended me on taking a vacation under the stresses of this profession. So I remember the special master commending me and quashing you. That's my recollection.
Are you here today pursuant to the subpoena?
Yes.
Okay. So your subpoena didn't get quashed, did it?
Yes, it did.
Sure didn't.
Yes, it did. Argumentative. Move on. What are you laughing at? Why do you keep laughing? What is it with you? Why don't you look at the camera and laugh at them?
Mr. Abrams,
Your
your testimony is being taken
Just
today.
ask me some questions about fraud, civil conspiracy, and what other trumped up things you did under your license that we're moving for sanctions against you. Do you realize we sued you for abuse of your law license? Do you realize that? And that we're going to continue to sue you for the way that you've been treating in this matter? You have no evidence. If you do, show the jury, put it in front of us, we'll ask questions. You haven't put one document in front of us. Open something up and make this a meaningful deposition or let me go.
Is there anything else you'd like to say, Mr. Abrams?
Depends on what your next question is.
In the motion that you filed to quash the subpoena, isn't it true that you admitted to the special master that you were in fact in town?
Object to form.
So Flashman here is asking about a special master. So it's so funny because every time I hear it, all I can think of, it just sounds like a BDSM thing to me. But basically, you usually hear about it more when it comes to civil cases because they're frequently used in depositions like here. In fact, with Shanna Gardner, that's the first time I've heard that I can think of any reference to a special master in a criminal trial. But basically, it's a third party appointed by a judge. And the point is that they are, well, like in Shanna Gardner's case, right? It's kind of to review the potential attorney-client privilege material. But what they're used for in this case, and most of the time when it comes to these depositions, is they are the person who is like for these people, like the babysitter or like the chaperone, right? Like, for example, because in a deposition, right, there's no judge. You've just got the parties. So like normally, right, if you've got an objection, the judge will rule, like in a trial, right? The judge will rule on the objection. But in a deposition, you've got obviously all kinds of objections going on. Objections are flying left and right, but there's no one to rule on it, right? So what normally will happen in a deposition is they're just put on the record. And that way it's noted for the record. But when the special master, when they're like saying, call the special master, it's because they're arguing and they can't sort it out. Basically, it's like they need intervention by the special master to make a decision and tell. Essentially, it's like they both think they're right, and they need someone to decide who's right, and to rule on that. Essentially, it would be like and I'm trying to think of another example. It'd be like I don't know, some sort of like a contest. I don't know. Let's say a race. Let's say it's a race or I don't know, some sort of a contest, right? Where there's no one watching it and there's no one there to judge it, right? Oh, I have a better example. Like the Olympics. Let's say it's the Olympics, right? And you've got let's say gymnasts, right? But there's no judges, okay? And then it's up to the actual athletes to decide who won, right? They would need help. That's not going to, it's kind of like that. So that's kind of how I interpret it. So because normally people can get through depositions without too many issues, right? Again, you just put it on the record and then you figure it out later. And that's why you put it on the record. But, they needed help within 2 minutes of this thing starting. So a special master is appointed by a judge to be again, like a third party who's not involved, who can make these decisions as needed. But also, like, again, in Shanna Gardner's case, they can also review potential, attorney-client privilege because of the fact they're a third party. So
We told the special master in a pleading that I returned at home at 3:30 in the morning on the same day that you scheduled my deposition, and that there was no way I was going to be able to come to the deposition with no sleep.
So you were in town at the time. You were in town on the time that you were scheduled to be deposed, but
Object
you
to
nevertheless moved
form.
to
Asked
quash.
and answered. Move on.
Mr. Abrams, are you refusing to answer?
I
Object
answered
to
the question.
form.
Move on.
You don't get to not answer when you object.
Object to form.
Do you
I
understand?
answered the question, and I even told you what time I returned on the day. What more? Why are you harassing me?
Mr. Abrams,
Stop harassing me.
listen to my questions. Today, that your job is to listen to my questions and answer your questions under oath. Do you understand?
Judge
Object to form.
asked and answered. Move on.
I'm waiting for your answer, Mr. Abrams.
Her first question was the same question you asked. If we need to go back to the very beginning to ask whether I said I would be here under oath, we can go back and ask the court reporter.
Mr. Abrams, in that motion, you included that Mr. Abrams' anxiety requires him to take medication on extended flights that impairs Mr. Abrams' facilities. Can you please explain what medication you were referring to in your filing?
Object to form
No.
medical privilege.
Privilege.
Medical privilege.
Yes.
The other thing that's funny is that they asked him, like, did you take anything, any pills? And he's taking
What
pills
is
at the moment. So there's that too.
Is that-
None of your
Absolutely
business.
no right.
No, what medicine I take is none of your business. Move on.
You filed a motion with the special master saying that because of a certain medication that you take, you could not sit for your deposition.
Yes, that medicine's none of your business. Move on.
And now
Objection
you've
privilege.
come into this deposition today with a handful of pills that you refuse to answer questions about
Yes,
what they are.
none of your business. HIPAA protection privilege. Move on.
We are going to continue this deposition now, Mr. Abrams.
Okay.
You have made it clear you are not willing to answer any of the questions today. You have been objecting. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition as well.
Please do.
For the record, since the moment we've walked in here, I and my counsel have answered every single question and rightfully asserted 30D, I think it's
30D3.
for harassment. We've answered every single question. We've asserted privilege where counsel refused to accept privilege. And we've been nothing but harassed under 30D3. We're moving for sanctions. We're moving to quash the deposition for future. And we're here to answer all of the questions regarding why my law firm was surreptitiously brought into this lawsuit for fraud, conspiracy, and aiding. And he hasn't asked one question in furtherance thereof.
We will
Until he
continue
does,
all three of the
we will
depositions
move
that
to
are scheduled
strike.
for today because it is very clear that Mr. Abrams, Mr. Sullenberger, and their firm intend to obstruct discovery in this matter and do not intend to answer the questions today. We will ask that it be reconvened before the special master with Abrams and Associates to pay the full amounts of everything associated with the depositions, including the special master's fee. And we will be filing a motion to take that up with the special master today.
We disagree. We're filing the exact same motion and seeking the exact same sanctions. Anything else?
We will continue the deposition and go off the record at this time.
We're going off the record at 9:38.
So one thing about depositions I will say is that they do have the potential to be really spicy because of the fact that you've just got the parties and there's no one there to help them out when they're fighting over things. But yeah, okay. So that was the first bit. Shout out to the special master, and he dodged a bullet on that one by being quote unquote out of the office. Okay, so up next, now we're getting into the regularly scheduled programming, as it were. So let me pull up, I think the first thing, so again, going in chronological order, we're going to start with the body cam, and because Mario was arrested first, we will start with that one. So give me just a moment. And let's see here. Okay. Okay, let me see. Oh, I just need to move it over to the other window thing. Can I pull it up over here? Why? Hold on. Okay, maybe I need to. Oh, that's because it is. Okay, I'm an idiot. Sorry, guys. All right, here we go. Okay, so that's why. Okay, now we have it. Now we have it. All right, cool. I was like, what am I looking at? And then I was looking at StreamYard and not the actual video. Okay, cool. Here we go.
Yeah, they're right on top. Oh, all right. Hang on. Good.
Come on.
Well, you're the one to ask stuff, right? I think it's cool. You're the one in charge. Well, the only keys that need to go to there is the vehicle keys, but
the other keys are yours?
The other keys are mine, correct?
I'm surprised. I'm surprised they've redacted all these law enforcement officers' faces. That's not. I mean, I've never seen that. I don't think. I mean, I was like, at first, I was like, are the kids around or are there other people? But no, I mean, look at, you can clearly see these are law enforcement officers.
What does that mean?
Interesting.
He's a low risk.
Yes. 1 second.
Go to where it says making a difference back there. So you're going to the back of my car. I'm going to search you real quick.
Sure.
Just go on the white stands for me. You got anything on you? Got anything on you?
No.
No?
Nope.
Really?
So he's the Orange County Sheriff's Department, right? Because that's where he was. And I'd forgotten that temporarily until I saw the slogan "Making a Difference," because God knows I've covered enough Orange County Sheriff stuff. Anyway, and that's when I was like, oh yeah, making a difference. I know who that is. It's Orange County Sheriff's Office.
First time in 10 years. You know, and you guys finally put your feet down.
Sir, one more question. Can I get in contact with my brother about my dogs?
Where are your dogs?
Oh, his
I have
dog.
3 dogs. They're at a townhouse, but I just need my brother to be able to take care of them.
Okay, we'll take care of that. We're not, you're not going to put you on the other side.
Okay.
I take care of the dog. Right.
Yeah, did you trade out customers? You want to trade them out now? Yeah.
Sure.
You can go back to how you were.
I would assume, well, I shouldn't assume. I just want to make a comment. Hopefully they had read his rights. Well, they should have. Okay. Where this video started, he was already from my perspective, he was already detained, right? Because he was sitting there. He wasn't allowed to go anywhere. He was just waiting to be handcuffed, essentially. So what I'm thinking is they're handcuffing him now. I've not heard anybody read him his rights. In my opinion, again, I think they should have already been read. But he also, why is that not on body cam? Because you want to get that on body cam for exactly this reason. So I don't know. Hopefully that was done.
Just lift your hands up.
So I don't know enough yet about the details of the situation. I have no idea. I think that will be difficult to assess until you know more about like their communications, you know.
Awesome. Thank you, brother.
I know literally nothing about their relationship at this juncture except for the fact that they were estranged and they're still married. That's literally like all I know about their relationship. So
Hey, no way to put these in the front, right?
No.
Isn't that a thing?
It's against policy, man.
I mean, to me it seems weird that he was even involved because like
That's your stuff. Okay. So this is a phone. It's on airplane mode. We're just gonna have you transport up there. Okay. Just turn it over to. Just hang on to it. We'll grab it.
okay.
All right. Sounds good. You know what? You can't take this stuff.
Yeah, so I'll weigh in on that when we get more information.
What's up?
Nobody told me like what's happening.
I'm just gonna take you.
Nobody told me what's happening. Okay, so I think what's happened, my guess was before he's going to say what's happening, I think he's going to have to be brought to the other, to Duval County. So sometimes we'll see this, right, where someone's arrested in one county, and then oftentimes what you'll hear them say, and I don't know how true this is, but what you'll hear the officer say is like, they don't actually know anything. They're just like literally the chauffeur, if you will. They just bring you over, and that's why. Having said that, they still should have read him his rights because he's being detained, and he's making statements. But yeah, so that would be my guess as to what's going on, but we'll see what they say.
And they're gonna talk to you down there. They'll inform you of everything down there. I don't really know. They just called me to transport. All right.
Transport, yeah, the chauffeur service.
To our headquarters.
That's what they always say. My thought whenever I hear this is like they do know, but they're not allowed to say it because they're not the law enforcement officers involved. That would be my thought. Like I
I've got
I can't imagine that they don't literally tell them anything, right? But that's what they all say.
Using your wallet and everything.
Keys, wallet, phone.
They still have your phone.
Oh my God, I know exactly what he's pulling up. That looks just like the Duval County system where I've been pulling up the docket, the colors and everything. That's really funny.
There's my phone.
That looks just like it. Is that what he's doing? I wonder if that's what he's doing.
I just got what they gave me, man. They'll bring everything else.
Oh, how
down there.
funny. That's got to be what he's looking at.
Okay.
Yeah, it's not extradited because it's not like out of state or out of a different country. You know, it wouldn't count as extradition. It's definitely a bigger process if there is extradition involved, like out of state, but it happens all the time, right? But yeah, this is normal, right? It's not uncommon for someone to be arrested in one county and have committed a crime the next county over. You know what I mean? It's more of like just the county lines are kind of a technical thing, but they have to be in the right jurisdiction and stuff. So. You know, the estranged part, I'm just thinking about this because so Shanna was in Washington. You know, I wonder, it's interesting. So he stayed in Florida. She was in Washington. You know, this makes me wonder something because, you know, I was thinking, I raised the question yesterday on the live stream about how, you know, it's interesting that they were both, her and Mario were both like equal, right? Versus like a middleman, such as we saw like with, you know, with Charlie and Donna Edelson, Katie McBanoa, right? Like them, like a middle person to get the hitman or whatever. And, you know, that's also Florida. And that's, you know, in other words, they didn't charge Katie the same as they charged the people who hired her to find somebody or whatever, right? And the reason I'm mentioning that is because if Shanna's living in Washington, right, just thinking logically about it, right, she's living in Washington and he's living in Florida still. And that could be also part of why they call them estranged, because literally they're living in other states. But we've seen this before in other cases where if somebody wants somebody dead, it benefits them if they're like on the other side of the country. Great example of that would be like Lori Vallow, right? Like she was like, yeah, I was in Hawaii when Tammy was killed, right? Just there's plenty of examples, but that's just one. You know, where it's like, you know, oh, it couldn't have been, I have an alibi, right? That type of thing. But, you know, what we see is oftentimes with people that they're like, I have an alibi. It's like, well, you hired the person or whatever, like it was committed on your behalf. So that almost, this is just, I'm going in order, so I don't have any more information. I'm just thinking about this logically, given the fact that she was in Washington, which I didn't know. I didn't realize that she was in Washington. So that A makes it kind of look like she was trying to distance herself, right? But B, if she did want something done, she would need someone locally to do it, right? So that makes me think, well, is that how Mario got involved? Because she needed someone who could find someone, because Henry Tenen is the guy who actually committed, you know, who actually shot her ex-husband. And I wonder if that, but again, that's why it's almost odd that Mario is being charged exactly the same as Shanna versus just, and I don't know the actual type of count. I don't that Katie was charged with, and of course she took a deal of some sort, but she was the middle person, right? Like an accessory. And so that would speak maybe to potentially the fact that he was more involved in the planning than maybe Katie was, where she was literally just finding a guy for Charlie. So yeah, it definitely has a lot of, there's some similarities for sure. Yeah. With the Edelsons. But again, it is interesting how he's not being considered an accessory. Obviously they're equal in that matter. So there must be a reason for that. You know, especially too, because like if they really thought that he was just an accessory, it could have benefited the state to charge him like that, because then again, just like with Katie McBanoa, you're more likely to get them to spill, you know, to make a deal and to testify against whoever it was that, you know, like he could have maybe got out but in a different way than, versus death penalty. But they must have seen that, their job as prosecutors, like they have a responsibility to charge the highest, for the highest offense, right? That they believe the evidence can prove. So if they believe that they have evidence, and this is what kind of answering my own question here, if they believe that they have evidence that could show that he committed first-degree murder, then they have a duty to charge that, Of course, as we know, things can also happen with plea deals where things are, they drop it down or whatever, but they couldn't just start out charging him lesser, right? They have to charge the highest level, but then it could, of course, again, be lessened from there. So hopefully that makes sense. Yeah, that's a good point. This case kind of like Valoshi, where people go back and forth and who is the mastermind lawyer, Chad. Yeah, and I honestly, I know all the details. I followed that case from the get-go, and I really don't have I don't even think I know the answer on that. It's hard to say, and I think that like it could really be equal. I mean, really, it's like, okay. Well, having said that, the only thing that I can say that might point to maybe Lori is the fact that there's a long history of suspicious deaths in her past, and Chad does not have that. She has a lot of history of suspicious deaths in people related to her, long before she met Chad, that were kind of never considered to be homicides, but there's a lot of suspicious circumstances and stuff like that. So, that being the case, that could point to maybe Lori being more of the mastermind. But yeah, I had temporarily forgotten that factor because I haven't thought about that part in a while. So yeah.
Head northeast, then turn left. Turn right.
Getting step-by-step directions. Oh my God, the music? What? No. Let me turn it off. Wow. So it's like, okay, this is the thing, right? Imagine if you've got kind of a longer drive too. It's like, what do you, do you sit in silence? I mean, you should. One should not say things, but sitting in silence would be awful too, right? Like I wouldn't, I have to have music or a trial. Like I don't drive in silence. It's not possible for me. I don't even know if I would know how to drive in silence. I feel like my feet wouldn't know which pedal is the brake and which one's the gas. Like so that blows my mind. But it's like, there was that little music and then he turned it off. I mean, I guess they can't play music. It's just interesting, this entire thing. Like imagine if you got kind of a long drive, right? Which I believe they kind of do. Let me look that up.
In 500 feet, turn right onto the ramp.
Well, at least they've got Siri to annoy them. So interesting. So it looks like it's actually 7 hours, and obviously this is not 7 hours. So I wonder, they must be taking him somewhere else first. So between Orange County and Duval County, it's 7 hours. Where did you get 2 hours and 9 minutes from? Oh, oops. Wait. Why is it? Hold on. It's trying to add North Carolina in this direction. weird.
Keep right at the fork.
Oh, I see what Google did. Google, okay. I was like, why am I getting 7 hours? Google put Orange County, North Carolina, and not Orange County, Florida. Hold on. Oh boy, that's so silly. Okay, 2 hours. Yes, 2 hours. Okay. Still, but this is not 2 hours. So I wonder if they cut some of it, or we'll see. If they or maybe there's a middle point. Okay, so he's sitting in silence. I wonder at what point does he start talking? Let's see. Oh, now they're arriving at their destination. Hold on, let's see, where are they going? Let's back this up. Where are y'all at?
In 1,000 feet, turn right.
Well, he did say, I mean, technically he talked, you know, he said, like, why am I here? You know, that counts. I mean, and he was talking when it first started, you know. Where are they taking him? I mean, we'll find out where he goes. Wow, the redactions are wild to me. So I bet he talks. So see, because now they're going to get him over to the people who can give him more information. So I bet this is where we're going to get more talking. Yeah, me neither. I tried to find that too. It's just like one statement where he asked for an attorney. That's all I've seen. You know, it's probably because of the fact that it could contain things that might be coming up in terms of him testifying for the state. You know what I mean? I could see how maybe that wouldn't. They could find ways to keep that under seal until after the trial. You know, because he's going to be a key witness for the state, like literally the whole thing hinged on him, you know, pleading, you know, taking that plea deal. Well, okay, let me see here. They're taking their sweet time to come out and get him. That's the part.
Yeah, it's not too comfortable. Hard plastic is great.
Actually, I don't mind the hard plastic because it actually feels good on my back. Believe it or not, but
I got a bad back. You need it firm.
yeah, oh yeah.
I guess the seats are plastic. That's crazy. I mean, obviously, if nothing else, yeah, clearly he's very cooperative, right? He's not, and it could be worse, right? He could be saying a lot more. He's saying that he's not complaining about the seats. That's good. Oh, wait, let me back that up a second. He showed where they were heading. Yeah. I can see it on the building there. Where is it? Whoa. Something else county. It started with a K. Oh, I wonder if it was, could you guys tell what county that was? Let me back it up one more time. Oh, no, it does say Orange, right? Hold on. It does say Orange. How did they get there so fast? Or wait, no, I'm an idiot because they're in Orange County. So they still have to get them to Duval. So there's going to be probably more transporting. Okay. So I guess Orange County is pretty big because, in other words, it took them this long to get to the station, but they were already in Orange County. Okay. So from here, they still have to get them to Duval.
I can't go that way. Perfect.
But that's going to be more, you know, that's going to be a longer drive.
Put me in the hole, the transport.
Yeah, you have no bond right now. You'll be extradited back to
How long does that normally
check.
take?
Depends.
So we did call it
when I
extradition.
get you.
Yeah, I actually had not heard anyone refer to it as extradition, just going in the same state. So now we know. I mean, he called it extradition, extraditing.
If you don't mind me asking, how old are you?
Whoa, what?
Probably a lot older than you think.
I mean, I can tell you the same thing. Do you remember back in the day when you'd have your phone, or you first get your phone, and you had to remember like every phone number?
Yep. I remember before cell phones, man.
Yeah, I remember beepers.
Wow.
So I was thinking just now. I was like, man, I don't know anybody's phone number anymore.
Yeah, I mean that's.
Yeah, I think I remember one or two.
Accurate. Yeah.
And that's because they had those numbers before cell phones were a thing.
Wow. I mean, at least he's not saying anything incriminating. No, it's not. Bond is not ever addressed. Which is interesting. I wonder if part of why they fight it more for Shanna is because she has kids, and they think they can use that, or they can try to use that as part of the argument. But it is odd that they don't ever argue again, because usually they always do. Well, where are they taking him now? This is interesting. No one was available, like at the Orange County Sheriff's Office or something.
I was thinking the same thing, man.
Hold on.
I was thinking the same thing, man.
I thought it was like a kid's toy or something.
At least he doesn't have speakers outside his car. Take that shit.
There's an ordinance now. We can stop people for it.
Thank goodness. That is the most annoying shit on the map.
It looks so sunny and warm there, man. Oh dear.
I'm gonna say it's 150 feet from the vehicle if you can be heard.
Was that?
The ordinance, I think it's 150 feet. If you can hear it from
Oh,
100.
you can hear it from 150 feet.
That was really interesting because the officer kind of continued the conversation with him. That is really unusual. I mean, wow. Wow.
Well, these dudes fucking make it as loud as they can go, so that's easy.
It's one thing for it to be loud. It's something else when like it's rattling the cars next to you.
Right, yeah.
I mean, Flash man, I
see the one where this guy got mad at another guy or something,
I
so
did
he
not-
opened his door to get the sound to go out and blew the guy's windows. I was like, dude,
I'd be so mad.
not that serious. And I think between that and people who cut the...
okay, I will say, like, as far as like I've just never seen that in this situation, right? You know, it's like, again, it all kind of hinges on like, has he been Mirandized? And I assume he has, but still, even if he has been Mirandized, it's like, it's just interesting that he's initiating conversation just about, you know, chit chat, you know what I mean? Like he wants to talk to him about whatever the fuck, like the speakers and just, you know, small talk or whatever. It's, I mean, again, thankfully he's not saying anything incriminating, but the thing is you never know, right? Because you just never know. I heard Runkle give a good example the other day, or I don't know, not the other day, recently, about like how if you could be, you know, you could be innocent, right, of a crime, and you know, but they've arrested you or whatever, and they could be like, you know, and that you could say, what was the example he gave? Is you could just be like, you know, they could be like, what's your favorite vegetable? Or you could just say like, I like tomatoes. That was an example he gives. If you're someone's like, I like tomatoes, and it just seems like the most benign, you know, comment, right? But without, unbeknownst to the person, they found tomato juice all over the crime scene. So they're like, oh, that's it, right? So that's the thing, is like, you just never know. So, but it does sound like just benign, you know, small talk or whatever. But if that's interesting, man.
Exhaust or just a straight
pipe.
And what you'll notice is because the officer reinitiated the conversation, Mario is talking more.
That's awesome.
Yep.
And I think the other thing is too, just to be on the safe side, usually they wouldn't do that, right? I guess he just, again, he must already be Mirandized, and he must have the officer, but still, I just feel like you just never, that just blows my mind. I've never seen that. Usually no one's asking questions until they get like interrogated. When, you know, once they're already in custody, right? It's different if you're just asking witnesses questions. You don't want to. Normally they're not. I don't think Mario has any kids. I don't think that. I think it would have, when that article I was reading last night, I didn't mention anything. I think he's much younger. Although he did say already he's older than he looks. Yeah, no, I don't. Sorry, I'm happy. So it looks like this is interesting. So it looks like there was Mario did talk to law enforcement in an interrogation, and I have not seen that released, but there's a summary of that from the investigator. It says on March 1st. What date is this body cam? Hold on, let's see. Let me show the date. So this is March 16th. So it says on March 1st. Oh, on March. So okay. So right after Jared died. Okay, on March 1st, 2022. Gardner and Fernandez came into police headquarters to be formally interviewed, it says. And there's a summary of Saldana's interview per the investigator. And then apparently, in addition to that, Shanna, where did it go? Yeah, so she had an extensive interview. I'm assuming they mean with law enforcement. Again, this is right after the death. I wonder if she was actually living in Florida at the time. Hold on. Yeah, so she was. Okay, so she must have moved to Washington State after this all went down, because on March 1st, again, when they came to be interviewed, they were interviewed at the same police headquarters, it looks like. So interesting. It's interesting that they became estranged. This is all very odd. Let's just see. Well, okay, this is what Shauna said apparently about her marriage to Mario. She said that they were married on Friday 13th, 2018 in Jacksonville. Nobody originally knew they got married. They didn't know each other very well. The reason they had to really get married is because Mario wanted to be involved with the kids, and the only way Jared would allow is if they were married. Well, so I guess that could explain why why they became estranged, right? Because it sounds like maybe, she said Mario and she had just started to date. She said she knew it would not be a typical marriage, but for the convenience. Wow, weird. They wanted what was best for the kids. Interesting. That's so interesting. Because parents that maybe don't get along or don't want to be married, how's that the best for? I don't know. Odd. Wow, this says Gardner apologized for being, quote, long-winded and stated she was told only to give yes or no answers. So what that sounds like to me is her attorney said, only answer yes or no, and she's been giving long-winded answers. So again, just like with Henry Tenon, so now we know, okay? They were all three of them were interrogated, I guess, interviewed. And none of that has been released except for that one statement from Henry asking for an attorney. So, wow. It says that according to her, she said that Jared had a good job making good money. Of course, this is later on, right? When he became the executive at Microsoft, she took him to court asking for child support since she was struggling to pay the bills. That's completely false. We know that. We know she's rich. She said she was working 3 jobs. I don't know that that's true either. Okay, yeah. So she was still living in Florida at the time. I want to know when she moved to Washington. Oh, okay. So then, it looks like she moved to Colorado or back to Colorado at some point. She stated Jared threatened to quit his job and move back to Jacksonville to not pay child support, which he did. She stated that Jared's fiance came with him, not realizing what she was getting into. However, she quickly moved away. Or maybe that's the fiance. I don't know. Gardner stated that Jared's fiance texted her frantic, stating there had been a fight and the police were called. She offered to his fiance to come to her house, but she wasn't just driving her. So she wasn't just driving around upset. Gardner stated, quote, she was broken spiritually. She's talking about the fiance. Gardner stated she stayed with her for 2 days and moved back to Colorado. Okay, so that's the fiance moved back to Colorado, I guess. So apparently this isn't his wife. I don't know. Okay, yeah. Okay, Gardner also mentioned that Jared wanted his fiance to be referred to as mom. She said that Jared's fiance left him, and then he met Kirsten, which is who he was married to when he was killed. Approximately 2 months later, they got married. Okay. And the same conversation came up with who to call mom. This is giving us some insight, right? Because apparently Jared wanted whoever, his fiance, and then later on Kirsten, he wanted them to be called mom. That is interesting. Gardner was asked if she knew the name of the ex-fiance, and she provided a name and a phone number. The way this looks is like this person might be made up. That's just how it looks from this article. She also stated, quote, and this is in quotes, good luck with Mario. He's like a pit bull, end quote. She stated he's going to be super serious. Well, that's not at all how he seems so far. That's interesting. What was the last thing she said in the interview? Gardner mentioned that the, quote, timing of all this is weird, quote, end quote, because she had just decided to, quote, let go, end quote, of the frustration and just make the best of the situation. She stated in moments of anger, she has thought how much easier this would be. Oh dear. But ultimately she wished no ill on them. Gardner stated she's willing to do whatever she can to help because nobody should have to go through this. She offered to turn over her text messages between her and Jared, but her attorney recommended we request those through them. So it doesn't talk about her moving to Washington, but that must have been relatively recently. And interesting. So, but remember, this is 2022. She was not arrested, okay, until August of 2023, okay? So this interview happened on March 1st of 2022. So what I'm saying is that she was, she moved out to Washington somewhere before that time, right? There's what is it, like a year and a half or whatever of time in between. So at this point, she's still in Florida right after the death. And then what it seems like probably happened, right, is Henry gets or wait. Yeah, so that's 2020, yeah. Because remember, all this time lapsed, right? So 2022, right, is when he's killed. And then pretty much quickly they get Henry Tenon, right? And then right after that, again, March 2022, they bring in Mario and Shanna for an interview. And they're both released, right? Because this is not until, hold on, where is it? Yeah, this isn't until March 16th of 2023, right? So essentially, almost exactly a year later, after the first interview, is when he gets arrested. And then Shauna is not arrested for another, 6 months or whatever. And she's not arrested until August of 2023. So in other words, during that interim of like March of 2022 and March of 2023, or I guess really August, she moves to Washington is what it looks like. So it would kind of look like what happened. The way this would appear to me is that what happens is after Henry, right? Henry gets arrested. And maybe it's after the plea deal. It'll be interesting to see the timing of all that. And I bet that's what the prosecution will try to bring in, right, too, because we know that he's arrested, and then like a month later he makes that plea deal. And I wonder if after he makes that plea deal, she moves to Washington State. I don't know, that's just speculation, but yeah, because she stuck around initially after the death. Because I think it was February is when he was shot, and again March 1st is when they came in for interviews. So. It's so interesting too, because like they got married so that he could have so that Mario could have a relationship with the kids, right? According to what Shanna said, right? And that it was a marriage more out of convenience or whatever, huh? And then, allegedly they killed Jared for pecuniary gain, but you could also say, was he in the way? I don't know, custody. It was the point. The point is this: it's like, if he was in the way of anything or whatever, it's interesting that, he's deceased, right? And then instead of them getting to be together and not worry about whatever, if that's what they wanted, if they did, what I mean, allegedly, they end up estranged. So it's like, was it all for nothing? I mean, I don't know. Of course it's always for nothing, right? There's no point, but it's just like, in other words, it's like, in their minds, was it all for, did they get what they, did they accomplish anything, if that was what happened? So. It'll be interesting to see how the state handles that, right? Like if they're going to try to show a motive, they don't have to. It'll be interesting to see if they do. Some more music. We're going to see Shannon's arrest here in just a second. I recognize that. That looks like the I guess the Orange County has like 2 places. I recognize this. This is the one I'm familiar with, the Orange County Sheriff's Office. They must have like another building, That's obviously okay. I recognize this. Okay. So he tried to take him to one location and they didn't have people there, and now he's at the right location. That's it. So, okay. I'm going to pull up Shanna here. Give me just a second here. Wait, that's not it. Oh, yes, it is. Okay, hold on. Let me do this. Okay.
.3026. They're making contact at the front door right now.
Who knows? So here she is in Washington. It was one of the kids, and she was 2 years old at the time. Yeah. Right. Okay. So I didn't see you. Okay, that's funny. I think these all came in late. So your comments here. Yeah, she ran. I mean, that's kind of what it's looking like a little bit, you know, like the timing of it, right? But yeah, the 2-year-old daughter was in the car, and that's why there's a charge there for both of them with the indictment for, you know, like there's a child abuse charge or something like that. Yeah, I have no idea if they'll take the stand in their own, in their the article lied to me. You know, it happens. That's why you just have to watch things for yourself, right? That's why we do what we do. I mean, he did talk. I don't know what the article said he said, but he did talk, you know. But yeah, so here they are for Shanna. Beautiful view. My God, that is sick. Look at that sick view. Wow. Wow. So you can see, here's what I was referencing. There's the date, 8/17/2023 is when, so this is, yeah, like a year and a half after the murder and after they first were interviewed and all that. Oh, interesting. So the only thing I can think of is if there's another body cam for him then having the next part where he's transported to Duval County. I didn't see that. But yeah, I don't know. I didn't hear anything incriminating at all. I mean, maybe unless the article was referencing his interview to law enforcement, which, you know, again, there's no video of. Maybe that's what they were referencing. I don't know. I believe that's Shanna's mom.
Yeah, we'll have to talk to these officers and say, okay?
So this redaction makes sense because the children are there.
I'm here, Shanna. I'm outside.
Oh, they're gonna call you. Oh, yeah. And I. You want me to go first?
Imagine how scary that would be for young kids if, like, did you see how many officers armed like that? You know what I mean? That'd be scary. Can you imagine they see their mom being taken out with all like that? I mean, I understand that they don't ever know what they're dealing with, you know, but like, I don't know, a lot of big guns. It's different when it's like you see how that dude's got the regular one on his hip. I don't even know, you know, type of firearm. I'm not a firearms person, but the other dude with the huge like AR whatever thing, again, not a gun person. You know, that would be really scary if you're a kid.
Yeah. Thank you. Sorry. Do you want me to go get a snacks? Yeah. Yeah, is that okay? Is that okay? That's fine. Abby? You have orders on the Instagram.
So this part's interesting.
For you, you have orders. So just,
you can hear the daughter.
Have grandma help you get into. Where are your jeans, Mom? And over there.
So this is, remember when I said last night that why aren't you pausing? Okay, there we go. Remember when I said last night that she makes some interesting comments, but I couldn't remember what they were? That's the thing. I'll probably back up so we hear it again, because here she is being arrested. with, and again, that would have been scary as a kid with all the gun. And she's like reminding her daughter that there's orders on the Instagram. Now, I guess this is for the bakery, because that's one of the things we read last night. I think it was last night, had said she had started a bakery. It could be for that. It also could be maybe related to Stampin' Up. Maybe they are helping with that. That's the company that her parents started that made them really rich. And I think is still a wildly successful company. Because I did go to the website when I was planning on doing research for all this. I did go to their website. They're still operating and selling like stamps. But yeah, isn't that, what do you guys make of that, if anything?
Orders on the Instagram.
Back up a little bit more.
Abby, you have orders on the Instagram that is managing for you. You have orders to just
I find
help you get into. Where are your jeans, Mom?
I find that surprising.
In the morning. They're on my Are those the jeans? I think it's on the box. The address.
So they're bringing her some jeans. You can see the jeans.
Yeah, they'll let her take what she has, and then they'll order more if they have to. Yeah.
Do you want to get all the medications in the bathroom on the counter and the drawer under the light? Okay. And then the
Redacted.
We'll just need to see like if it's valid.
Dude, like look at this dude on the left with that type of gun. If I was a child, okay, not even if I was a child. If I was like around that in person, I would be terrified. That's just me. Never been around a gun. That just looks so extreme. But yeah, I don't know, crazy. So they're telling her she can't be given her medications, but she'll be evaluated, at the facility where she's taken.
You guys smiling for the ring camera?
Oh my God, he said, "Are you guys smiling for the ring camera?"
Whoa. She's in the bathroom changing.
Oh.
So they're going to need the prescriptions in their pill bottle.
I don't know how she's changing. So what he's saying is they're going to need the prescriptions like of the pill bottle, but she can't bring the pills with her. I don't know how she's changing in the bathroom with her hands cuffed. I didn't see any female officers there to assist her because, they can't just let her, now she's detained. I guess she's having to figure it out with handcuffs on behind her back, Shout out to Iowa. Glad you're here, friend. Awesome. Glad you had a wonderful day. Oh, you're in the city. Interesting. The city. Yeah, so we're just going through all this body cam at this juncture here. So. I think she probably had a heads up that this was happening because of the fact that her mom was there. My understanding is that her family living in Utah. Unless by chance her mom was just visiting, but like you can imagine how she's a single mom, like, you know, ostensibly, right? To our knowledge, her husband, strange husband's in Florida. And that, so I don't know how she ended up in Washington. That's another interesting thing, right? If her family's in Utah, like what's she doing in Washington? But anyway, that it would be a situation, right? Because, well, you know, the kids, and we know that her mom, Shanna's mom, was given, well, both her parents were given custody after this. So that must have been, I don't know if that was arranged ahead of time or what, but it seems like it because of the way the mom was already there. But again, to my knowledge, they were living in Utah. And so she must have had to get from Utah to Washington. So.
Yeah, I just don't know. I didn't know what they wanted to throw them in there. All the properties to be taken. Grabbed like 5 of those yesterday. I don't know.
One thing too that we have learned from covering Koberger, especially, is that even things that might not be obvious can matter when states are involved.
Yeah, they should have some in there.
I guess the relevance of what I'm saying is that, like, I would imagine they searched, and I haven't looked for this. I don't even know if I'm trying to remember if it was there. I just didn't read it. I would imagine there was a search warrant for the house, for her house, this house, right? I'll have to go double check and go see, because, you know, that was one of the things I was going to say is, like, each state has its own, you know, state constitution that has everything that's in the U.S. Constitution, right? You can't take it away, but you can add more. And I know from covering Koberger that Washington does actually have additional, well, and as does Idaho, additional specific things that protect your privacy during, like, the fourth, like in reference to the Fourth Amendment, right? Protects your privacy over and above what's the standard from the U.S. Constitution. Like, it's, you've got a little bit more rights, and there's, you know, some more specific things going on with that. So it'll be interesting to see, you know, see if that's available, like the search warrant or the return. But yeah, I was just going to say, like, whenever there's an arrest or a search or anything like that out of state, you know, it can complicate things depending on what's going on. But yeah, just to remember that every state has its own specific constitution, and that's, you know, Fourth Amendment search and seizure. So.
No, probably gonna have to do the booking process, and then it should be good to go.
Maybe I'll take her to the PD first.
We could transport her to our PD. And...
That's what I'm saying. We're going to the PD first. So.
Oh, okay. Yeah. I thought the jail.
We'll try right. Can I email you the form?
Ashban, that is a fact. For sure, that is a fact. Yep. Exactly. And that's why it matters. They should always be careful, but you know what? They probably wouldn't if they didn't know that they were going to be likely held under scrutiny and probably being cross-examined by the likes of Jose Baez. Like, good luck with that, people. Good luck with that. I mean, what we have seen, I mean, it'll be interesting. It'll be really interesting, you know, because he turned every state witness into a witness for the defense. In case Anthony's.
They're changing games. That's the last thing I heard.
I think she's using the bathroom. Too.
Yeah, I wonder how they're doing that, because they need to be supervised, but I didn't see any female, and they can't have a dude cop watching these back. Not something that can happen. Can you imagine the type of lawsuit that would happen? I mean,
I don't know what this asthma stuff is. But it's powder they buy, won't let it in the jail.
I guess pills only, I think.
So now they're saying she can take her pill? She couldn't. no uniform, no gun. That dude with that stupid gun. Okay, she's got her jeans. Okay, there's.
It's gonna be the
Okay, I take it back. So
white vehicle back there.
So there, okay, at least I can, oh my God, why won't you talk? Now I feel a lot better because now there's a female officer. So thank God. I was like really wondering like what's going to be going on because that's, yeah, okay. So that's who was supervising her as she was changing. So that's all good.
We'll go to the passenger side. Yep.
Stop.
So this is likely the last time she's seen her kids to this date because, you know, again, her parents have custody. And again, I believe they're in Utah with the kids. And, you know, she said, love you, honey. And now she's in Florida, you know, across the country facing the death penalty. Oh, what do you mean? Like on a stream now? Like on camera or what?
Is that property?
Medicine. Good. That's your medicines. I don't know what y'all want to do with it, but most of them are prescription. So we'll follow you over to.
So, detective was saying going to the PD.
You know
we do
what?
have interview rooms
Perfect.
within the PD, so we could take her over there.
That's yeah.
Interview rooms. So again, would be a separate interview. So because she already had the one in Florida. So you know what? It just dawned on me that the reason I didn't see anything about the search warrant is because that would not be on the docket for Duval County. I didn't even think about it. I didn't even know until Flashbang earlier told me that I didn't realize she was in Washington. So what I'll have to do is see if I can find that, but that'll be out of Washington. That's why.
Pull her out.
Yeah, if you want to bring her there, and then we'll follow behind you and we'll go.
Okay.
Well, that's cool. What's the panel for, Flashbang?
So just a heads up. I don't know if the jail is gonna take anything not in the bottle. Okay. Otherwise, it looks like everything else is good to go.
I'll leave y'all up to whatever you guys decide.
We could try, but I think the jail will probably say no to that.
That's fine.
Oh, that's cool. Alternate juror. Blah, 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 I can't talk. Alternate juror. I feel like I've heard of that channel. That's cool. That's fun. What are you do you know what you're gonna be talking about? So for anyone.
This is West 30. Could you pass me the SP primary, please?
For anyone who's joining us, we are currently on the body cam of Shanna being arrested. This is from August 17th, 2023, and this is in Washington State. In general, but the wind is loud. I wonder if the seats are plastic like they are in Florida. That's crazy that the neighbors have like a big bus. Why?
Jail or to the PD.
Going ahead until something happens. It's interesting. What's she gonna do, man? Gonna talk?
Is it hot back there? Not hot.
Oh, he has this computer thing. They usually technical term, computer thing. Oh, interesting. Cool. I'm sure you'll have fun. I'll try to tune in if I can. Yeah. I remember, and I figured that's what you were. I knew that's what you were talking about. That's cool. Yeah, I'll try to tune in if I can, so I can say hi. Yeah, I've never had anybody on. I don't even know. I mean, it's like a whole other thing to think about, you know? She's not saying anything yet. Good girl. Keep your mouth shut, people. Don't self-snitch. No self-snitching. So far, she's quiet. I've got some students that live in Washington State, and they live. I wonder if they're kind of near, because, like, Review to County. I wonder if that's Mount Rainier. Beautiful. On the road again. Why are you scared, Flash? You have a lot of fun. Be yourself. Okay, they're at their destination, apparently. So. What a gear they have going on there. I could be overwhelming. Good thing I'm not a police officer. Right? I'd be careful. Last thing I'd ever do. Can't even fathom. Look at it's so crazy when you think about, right? Like look at the difference. Just sake of, like the difference of this, facility versus in Orange County. Like that facility in Orange County is like a sprawling metropolis. It's huge. And there's a lot of cars. Look at this. This is like, no, there's nothing going on. They got a dude waiting with the door open, versus like when they pulled up there in Orange County, finally, the last one, it's like a very secure gate and like, armored door type thing. Very different, right? But of course, we all know they got a lot of people to process there in Orange County, and this looks kind of more chill. So again, I don't know yet what county. What did it say? Richland, city of Richland, I think is what it said. I'll look that up and see kind of where that's at. But I wonder if they don't get a whole lot of, homicides and whatnot.
I think my cage camera's not working. So I have to get my body cam on.
Please do. All right.
What?
Richland. Let's turn it down. The background wind or whatever it is really loud. So Richland is a city in Benton County, Washington. Its 2020 population in year 2020 was 60,000 people. It's right on the rivers. It's got the Yakima and the Columbia rivers, so not mountains but rivers, I guess.
Bodycam will be
So
turned
she's
off
probably
in
the
back
Benton
where
County
cameras are.
Police Department. Yeah, they did say they were going to the police department and not the sheriff. So, oh, now they're back at the house. So what's happening is it's switching body cams. Let me go back in just a second so we'll see. Hold on. What are they doing? I was looking at my phone so I could read this to you guys. This is a timestamp. This is at 9/11. Let's see. Axon 3.
Bodycam will be turned off in the back lot of the PD where cameras are in view.
Oh, okay. Okay, so this is back. So this has Axon Body 3, but if you look at the timestamp, this is back at the beginning. So this would be, I would imagine, another camera, like from a different officer. So back at the beginning of the whole thing, the arrest.
Yep.
So she didn't really say anything except getting her jeans and whatnot. Oh, okay. He's going to talk to the mom, maybe? Oh, first time on a YouTube stream. Right? I know. Oh, she's crying, I think. So yeah, so Shanna was taken then to the Richland Police Department, I think is what they happened there. So it's a small town.
Yeah, we'll have to talk to.
Oh, what did she say? Oh, let me, you know what? Let me turn the sound back up so we can hear what she's saying.
Can I be with the kids, or can you at least bring the kids out to me?
Yeah, we'll have to talk to these officers inside, okay?
I'm here, Shanna. I'm outside.
Oh, they're gonna call you.
Oh, yeah.
Probably. Can I?
You want me to go get her shoes?
Should I put pants on? She said.
You can roll up to the front if you want.
Liam was on top of me. He came inside. I heard him taking that side.
Yep.
Is that okay?
Still good with him. You guys good with everyone back in?
You go ahead, go on the kids. Yeah.
Thank you. Oh, sorry. Do you want me to go get her pants?
Which ones want your jeans?
Yeah.
Is that okay?
Is that okay?
That's fine. Okay.
Abby? Oh, no. I say, you have orders on your.
Here we go with this.
That is managing for you. You have orders.
Oh boy. That is just that's weird though, man.
Have grandma help you get into. Where are your jeans, Mom? I know where they are.
Oh, she's wearing chacos. I have chacos.
medications in the morning. They're on my counter in the bathroom. And those the cheese? It was on the box. The Advil, my Advil.
They let her take prescription medication to the jail with them? Or is that?
Yeah, they'll let her take what she has, and then they'll order more if they have to. Yeah.
Do you want to get all my medications are in my bathroom on my counter?
Okay, I thought they said earlier that she couldn't, but yeah, okay. So it'll be different when she's transferred.
It has a box
She'll
that
be
I don't
extradited and all that. It'll be different. I don't think they'll let her have taken those in Florida.
We'll just need to see like it's a valid.
Like, there's no way. Like, we've seen that in other body cam in Florida. Like, there, if you're like, your medications, no way, no way, not happening.
Oh, okay. Okay. Yeah.
It's weird that there's that person that like isn't wearing any garb. Like, who are you and what is that? Why are you like that?
The guy one good smile.
Like an unidentified. I mean, the thing is that actually could be an issue because they actually are supposed to be identifiable, and that's part of the thing with the uniform. So the person just wearing all black, like nothing, no badge, no neck badge, no neck badge, no nothing. Literally, that, I mean, because that's an issue. We actually heard this in trials, right? When you've got, even if it's just like plainclothes officers, right? In this case, it's almost weird that they're just like in all black, but like doesn't say anything on it. Because that's part of it, right? Is like that they need to know that you're law enforcement, and anyway, it's just interesting that they're like that. Whoa. What have we here? What have we here? Sound is off, but they're going to bring her in. Okay, interesting. Wow. There's a bathroom. This is interesting. Getting to see inside. Wow. Beautiful big doors with lots of natural light.
We're gonna bring you inside real quick. Get you out of the long car, right?
These aren't shotguns. These are Birkenstocks. Never mind.
Now step out for me. We're gonna go through these doors over here.
No, I can't even imagine like being arrested and like.
And then there's gonna be a hallway to your left there. Have you take a left there for me?
Left.
And we'll go down to this last door here on the left.
Interview
Stand
room.
there for me.
Probably. Oh my God, interview room. That's awful.
And I'll have you take a seat over here. And what I'll do, actually, if you want to face the wall for me. So what I'll do is I don't want to keep you in these cuffs for a long time. I know they kind of hurt. So what I'll do is I'll take one hand out and I'm just going to attach it to the railing right there. All right.
Interesting. They don't always do that. I mean, they rarely do that. That's interesting. That they're when they do that, it's because they're hoping you're going to talk. That's when they do that. Like, oh, if we spoil you by taking one hand out, maybe you'll talk.
If you want to take that hand, place the top of your head for me.
Put your hand on your.
And then do you want to step to your left or turn the other way? I'll have you take a seat.
I don't know why you do that.
Turn the other way for me. All right. And then if you want to take a seat for me.
Weird instructions.
No, you're okay.
Weird instructions.
I'm just going to scoot you a little bit. There you go.
Wow.
And then the other officers will be in here shortly, all right?
It's so wild. They just take you right into the room, like, wow. Wow.
I guess it doesn't really matter. But I was going to say pulling up the camera footage, but I can just stand here. So Chair. I'm good.
Wow. This is interesting. We don't usually get to see this, not background noise, we don't usually get to see this perspective of like them, you know, on the outside preparing for the interview type thing, assuming he's going to be the one, or I don't know. It's interesting. You know that they always get left in the room by themselves for a period of time, you know. Okay, let's go forward a little bit. See if anything happens. Okay, now what? So my guess is she didn't talk, right? We know she did talk. She was interviewed a year prior, actually a year and a half prior, right? But at this juncture would be, yeah. So that would be my guess, is that she's like, nope. And then attorney, whatever. And then they're like, all right, we're going to get you on out of here and ship you off to Florida. That would be what I think is probably happening there.
Which one's tight?
The right one's more.
The right one's more tight.
But it's okay.
I'll loosen it a little bit.
Weird that they have to use different handcuffs. Now it does look like there's a lot of Kleenex over
Are those cuffs putting any strain on your shoulders or anything?
All right, but it's okay.
Do you guys see all the, like, there's like a bunch of Kleenex or something on that table? So maybe she did, I don't know, maybe she did talk, and, or maybe she just left her there. I don't know. It looks like, in other words, or you know what I can do? Let's just take a look and see how much time has elapsed. That's the smart thing to do, to see how long she was in there. Let's do that. So let me go back to this part. Okay, so less than an hour. It went from 9:25 to 10. What did it say? 10:32, or not? Yeah. So just about an hour. So she might have just that's not very long. Like, in other words, I think she either sat in there and like they made her wait, and then she said, no, I'm not going to talk, or basically that wouldn't be long enough if she said anything. You know what I mean? Most of the time you see people waiting for that long before somebody even comes in to talk to them, or long.
Which one's tight?
But I wonder if she was like sitting there.
The right one's more tight.
I'm just wondering what's the deal with all the Kleenexes. Yeah. Yeah. That's what I thought.
I'll loosen it a little bit.
I mean, maybe she was just crying but not talking, you know? That's possible. I guess you can kind of hear some sniffling, so. Yeah.
Are those cuffs putting any strain on your shoulders or anything?
All right, but it's okay.
Okay. Well, I'll get you down to jail as soon as possible, and then we'll get you out of these cuffs.
How far away is the jail?
Probably in about 10, 15 minutes.
10 minutes, there's a bunch of construction stuff.
I feel bad. Do you want me to grab this and put it in the trash?
No, we'll get it for you. That's all right.
She wanted to clean up the tissues. You need.
Do you want any more water before we go?
You know what though? Fuck. You know what? I wonder if the reason she said. So I was just thinking. I was like, wow, I've never heard a defendant offer that, or someone who's a suspect at this point be offered. But you know what? I wonder if the reason is because of DNA. Maybe. Could be. Because like that's really unusual that they're like, do I need to clean up? Especially when you're handcuffed, right? You don't have any hands free. But I wonder if she's like thinking, I don't know. But she did say throw it in the trash and they could get it out of the trash. So I don't know.
You want a little bit left?
Yeah, she was crying for sure. Get some nice DNA on that water bottle. I mean, they'll buckle swab her anyway when she gets to it.
Good. And then we'll just go back out to the same car we came in. There's this one on here on the left. And what I'll have you do is I'll just have you face the numbers right here. Just because you were in that room, I am just going to pat you down. Just to make sure nothing else ended up in your pockets.
You didn't steal any Kleenex. No Kleenex for you, ma'am.
And then I still do have your medications with me.
Okay.
So those will be checked into the jail. Just want to have C for me. I do have a question for you. It's not regards to the charges at all. Those the medication that's in that little divider.
Yeah.
What's in those?
I can tell you.
So redacted for, I'll just jump ahead. It was longer than I thought, but I guess she's talking about her medical conditions or something.
This is because the jail might not take that divider.
That's fine. I
don't
have
know.
enough in the bottles. Okay. I think there was only a day left, is what my mom said.
Okay. And if you have them in the bottles, then that's good. I just saw that in there, and the jail is pretty picky on prescriptions.
Yeah. No, I figured the divider my mom can come and get. Because
and then I am just going to read you just since I have you in my custody.
Yeah,
I don't know what the detectives asked you. I'm just going to read you something.
So, like, had this not happened before? Because I can't fathom that. There's no way.
So you have the right to counsel at this time. If you're unable to pay for counsel, you'll be entitled to have one provided without charge. Do you understand that? And that's it. So I
mean, there's no way they had to.
I'll get you down there. It's hot. So hot, my vehicle can't keep up.
I say it's hotter for you guys wearing all the stuff you guys have to do.
And I'll get you down there so you're out of cuffs. I know those are uncomfortable. So just sit tight for me, all right?
Cuffs in there, they belong to ATF?
I think they're detectives, Jacksonville.
Oh, okay.
But
Warrant?
yeah, I got the two.
Oh, so the detective, right? So then that they did try to interview her because essentially he just said the detectives from Jacksonville. So that's what will happen, right? The detectives will go to the place because they want to interview you. So that was what happened. They put her in that interview room. The detectives came all that way, and she's like, "Nah, that's what I'm thinking." Probably went down. Let's waste taxpayer dollars, though. I'm like,
that. Looks like another part of the warrant here.
Okay. I'll need some. Give me a call.
Okay.
Give me a call.
All right. Well, he gave me his business card, so if I have some type of document issue, I'll give him a call.
Okay.
I'll also give you a call.
Sounds good. Get these cups back in.
wow, Flash fan. Can you imagine? That is insane. That is insane. you know, at that rate, you might think, considering all the stuff they have to do, right? Like that's, you know, they'd have to stay overnight. Like none of this is a small task when you're doing it. You know, I was just thinking to myself, it might actually cost less taxpayer dollars to fly them, honestly, because then it's, you know, I wonder how long of a flight that is, but obviously that would probably be better versus that type of drive, because that drive is going to take a lot longer when you're traveling with someone in custody and then you're having to stay overnight and everything is like there's so much they have to do, right? Every time they move you and go to the bathroom, it's a whole thing, you know, a lot of stuff. Yeah, I don't know.
Hey, this is West 30. Can you pass me to?
I would imagine that probably came up in the extradition hearing about, you know, how she would be transported.
Primary, please. Thank you. This is West 30. I was just calling to let you know I have my in custody back on board, and I'll be en route to the jail. Starting mileage will be 13.0. Perfect. Thank you. Bye.
Oh, so I was looking into, I guess I can just turn it down. Because we'll hear it if somebody talks. That noise is loud. So it says that she moved. I was looking to see about if they flew her. It says, so this is the part we've been speculating on about the move to Washington. So she moved from Jacksonville Beach to West Richland, Washington with her 2 kids. They're twins. The son and daughter are twins. You know, Mario stayed in Florida. It says it followed wide speculation and media attention surrounding the death of Benign. So what we were saying about her running, like that's like, so yeah, after she left the state, she got the heck out of there. Not saying how they transferred it. Oh. And that's it. Okay, so I was just looking to see if this details at all how they got her there. She wasn't extradited for a couple of weeks, apparently. Prosecutors are not disclosing details about getting her back across the country for security reasons. Gosh darn it. We want to know. Yeah. I mean, yeah, and the reason we didn't watch the extradition hearing is because I figured that usually what happens, and this is what happened in this case, is they waive essentially they don't contest it. They're like, yep, you can, because really the only way you can do that is if, like, for example, you're contesting that they have their own person. Like, in other words, the name Michael Smith, and there's like a bunch of Michael Smiths. It's like, I'm not Michael Smith. Like, that's really kind of the only way that you can contest it, because yeah. So it's like as if they have the wrong person type of thing. So what happened was she did exactly what everybody does usually, which is like, yep, I don't contest it. And then, okay. And that's all it is. But they aren't being specific about anything else. So that's what that is. Thank you. So that's 6 hours and 40 minutes for a nonstop flight. Yeah. I mean, much more reasonable, but yeah, they're not telling us. That sucks. I wonder if they made the drive. Okay. So next up, we are going to, let me pull it up here. Boop, 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 boop. All right. I have to unshare, reshare. Because it is time for the next document. The big one with all caps, bold, underlined. Yes. All the spice. Yeah. So it was only a 4-minute hearing. Yeah, that tracks. That makes sense. That's what I would expect. All righty. So here we are. Here it is, guys. Defendant Shanna Lee Gardner's supplemental pleading to motion to disqualify the office of the state attorney and motion to dismiss the indictment for violation of the Sixth Amendment, right to counsel, prosecutorial misconduct, and outrageous government conduct. Citing her 5th, 6th, and 14th Amendments. The grounds for this motion are the state's willful, knowing, and intentional violation of the attorney-client privilege and egregious disregard of a court-ratified agreement to use a, quote, taint team, end quote. Procedural history. Jared Bridegan was killed on February 16, 2022. They shared twins. They were age 9 at the time. After the killing, okay. We're going to learn some more information. After the killing on February 17th, 2022, by text message, Mrs. Bridegan asked Mr. Gardner to remain silent to the media and to protect the family's privacy for the sake of the children. So it sounds like, well, I don't know. It sounds almost like she didn't suspect her or something. I don't know. So because she told her to remain silent. Like if you really think someone's guilty, you'd probably be like, yeah, go talk. I don't know. Anyway, Ms. Gardner responded with, I agree 100% and abided by that promise. Unfortunately, Ms. Gardner's relationship with Mrs. Bridegan deteriorated thereafter. By March 2022, Mrs. Bridegan was routinely engaging the press and continues to do so. Interesting. In April 2022, the media began to release photographs of Ms. Gardner and her twin children without her parental consent. In response, Ms. Gardner sought legal advice regarding the portrayal of minors in the media. Therefore, Ms. Gardner retained the Bedell law firm to assist in protecting her children's privacy. I remember when that happened because they shouldn't have done that. But I think this matters because they're giving another reason why she sought counsel so early, and that it's like not because she did it. You know what I mean? Because we talked about this last night, but that it's more like because of the kids, right? No later than August 2022, the Fourth Circuit State Attorney's Office, Assistant State Attorney Christina Stifler, the lead prosecutor overseeing the investigation into Mr. Bridegan's killing, was informed that Ms. Gardner was represented by, and there's Mr. Coxey. So I don't know if that's how you say it correctly, but he's still representing her. So they added, more people, including Mr. Baez, but that's who was the original, and he's still representing her. And that her now co-defendant, Mario Fernandez Saldana, was represented by separate counsel. By September 2022, as the result of a narrative that Ms. Gardner was involved in the killing, the twins and Ms. Gardner were subjected to harassment. So they're saying she had to leave because of the harassment. That's where this is going, right? Subjected to harassment in the community, and her small baking business was no longer receiving orders. Ms. Gardner was offered employment in West Richland, Washington, a location where the altitude was also congruent for her twin son's severe medical issues. Interesting. Okay, so that explains the move to Washington, because remember when I was like, why Washington? And I had seen stuff about that, how her twin son has issues, medical issues. She was offered employment, though. I wonder what that is, because the whole thing about they have Instagram orders. I remember I thought that was either the baking business or the for Stampin' Up or whatever. But maybe we'll learn more. So okay. But I think the main reason to move there would have been for the altitude and then to escape Florida, whether it's because you're subjected to harassment or whatever the purpose is, right? Okay, on February 6th, federal law enforcement working closely with the Fourth Circuit executed a search warrant on Miss Gardner's home and vehicle in West Richland. So there we go. There's that one. Seizing all of her electronic devices and all the shit's listed. On or about February 7th, federal law notified ASA Stifler that the devices seized likely contained communications protected by attorney-client privilege. There it is. And remember, just like we talked about last night, right? Remember how we said that, like, you know, they can obtain an attorney, right? And then part of the reason for that is maybe so that you can be like, oh, this is attorney-client privilege, right? In this case, she has a better, well, I don't want to say excuse because, again, anybody can retain counsel whenever they want, but she has an, you know, in terms of when this goes before a jury, right? If you're trying to, if a prosecutor is trying to be like, oh, it's consciousness of guilt, right? For her, because of the fact that her children's pictures were put in the media and that's when she obtained the firm, you know, that gives her a little bit better of a explanation versus Mario if jurors are concerned with that type of thing. But I immediately, when I read it, I was like, yeah, it's going to be for the same thing because they're going to be citing that attorney-client privilege. Okay, on February 16th, 2023, Mr. Coxey filed a motion for a protective order and additional relief in the circuit court, seeking, quote, an order enjoining further review of the material seized by law enforcement and until a detached magistrate, special master, there that is, or other neutral party is appointed to review the contents of any seized item for communications privileged under the husband-wife privilege or the lawyer-client privilege. So this is all stuff that we are pretty much, oh, it's pronounced Cox, thank you. Oh, who made statements? Who made statements? The ASA Stifler. So where am I clicking on? Okay, is it Cox? Okay. That's funny with the E at the end. Anyway, so there's the special master or other neutral parties approved to or appointed to review the contents of any seized item for the communications privilege under, oh, right. Yes, I already read that. Husband-wife privilege or the lawyer-client privilege. Yes. So we are very familiar with what's going on with that. Okay. So sometime before February 17th, Jacksonville Beach Police Department Detective Jason Lamont, with the assistance of ASA Stifler, drafted search warrants to complete forensic extractions of her devices. These warrant applications made no mention that the devices contain communications protected by attorney-client privilege and do not describe any protocol to put in place to ensure that attorney-client communications are filtered from the prosecution team. Also on February 17th, a hearing on Mr. Cox's motion was held and okay, so my brain was computing because the hearing that we watched last night was on February 16th. Okay. And remember, the judge decided she was going to bring in another judge to help deal with this separate issue. So this is what this is telling us. That hearing was the next day. That's what we're seeing here. Of course, that was in camera naturally, right? So this hearing was in camera and it's exactly what we heard described last night. So I love the chronological order of the things happening so quickly here. The same circuit judge who was overseeing the aforementioned warrants. The hearing was held jointly with Mr. Fernandez-Saldana's counsel. State was represented. Okay, we don't need to go through all that. Okay, Mr. Cox raised concerns about use of a taint team to remove attorney-client communications. I brought a protocol that the United States Department of Justice uses for taint teams, although I think Mr. Dreiser is not a fan of taint teams, and I would say that I'm not a fan of taint teams either. There's been too many articles that they don't abide by what they're supposed to do, and there's a footnote. Despite the reference to the U.S. Department of Justice protocol, what actually happened in this case is far from even those protocols employed by the DOJ that have been sharply criticized by federal courts. Those protocols often involve a team of DOJ lawyers and law enforcement completely walled off from the case review of evidence. What they're saying is, again, here they're like that they're suggesting to use that protocol as an example, even though that protocol is considered to be really faulty, apparently, right? Like it's not really that great. It's not enough protection, but that what happened in this case fell way short of even that. Despite these concerns related to the execution of a taint procedure, all parties agreed that a taint team would be put in place so that the prosecution team would never see attorney-client communications, specifically the assistant state attorneys. And this is all, we don't need to read all of this because this is kind of what we heard about before. Make sure we never see it. And some of this was in Mario's motion. Miss Gardner's counsel made clear that they expected text messages and emails from counsel to be on her devices. On February 22nd, the circuit judge issued an order denying the motion with respect to spousal privilege, but recognizing in a footnote that the parties had agreed that all attorney-client, right. So in other words, the spousal privilege in terms of communications is not privileged, right, in this case, right? So there's two different types. There's like spousal privilege and then there's like communications privilege, and they both kind of fall under the same umbrella, but there's a difference in that there's like spousal privilege, which when it comes to testifying against each other, we've talked about that. But then there's also the marital communications, which in this case, they're saying that's fair game. Right. The state has agreed that any communications protected by attorney-client privilege will be removed from the devices by a non-state third party, of course, right? Yeah, some of this was also, again, in Mario's motion. Okay, on February 27th, the prosecution team held a meeting at the U.S. Secret Service field office in Jacksonville. Despite this being a purely state criminal prosecution from the start, by February 2023, federal law enforcement from Florida to Texas to Washington state were actively involved. Why Texas? The meeting was attended by members of the Secret Service, the Jacksonville Beach Police Department, the U.S. Bureau of Alcohol, Tobacco, and Firearms, and ASA Stifler. Wow. At the meeting, the prosecution team discussed the issue of attorney-client communications, and it was decided that a single USS special agent would perform the filter duties or serve as the taint team. Okay. Accordingly, it was understood that all 6 devices from Mr. Fernandez Saldana and Ms. Gardner would be filtered through S.A. Nazario to remove all attorney-client communications. They took the devices. Despite good intentions, S.A. Nazario was ill-equipped to serve as the taint team. S.A. Nazario had no prior experience serving on a taint team, no training associated. Oh, okay. Also, there's a footnote. Okay, well, we'll get to that. No training associated with such responsibilities, and he was given no protocol to be followed. Here's the footnote. He's likely a Category A witness in this case, which creates a secondary issue. Agent Nazario performed the actual forensic extractions of many of the devices. He's hardly the non-state third party. Yeah. Oh, boy. Yeah. Oh, you're saying the new wife made statements about it. Okay. Yeah, I have a suspicion or a thought that maybe, at least in terms of how they are paying for it, I bet it was Shanna's family. I mean, if I had to guess, right? Because it would benefit Shanna as well for him to have counsel, good counsel, if they're going to be tried jointly. Okay, so he was given, and this is, again, we've heard about this, the list of attorneys, we know about that. So then as it pertains to the iCloud, right? This is reminiscent of Koberger. This included the contents of all emails and contents of all instant messages. So this reminds me of Koberger in the sense that this sounds overbroad, right? Overbroad. They're not supposed to be doing that. I bet they're going to argue about that as well at some point. So then they identified the relevant iCloud account. Oh, okay. So then this detective obtained a warrant from a different circuit judge than the one that presided over the February 17th hearing to obtain her Google data. This came up earlier. This is in question, this thing about the Google data. And Detective Johns made no mention about February. That's interesting because, in other words, he went to a different judge, and that special judge was appointed to handle all this stuff. And then there's a footnote. Overlooked were Ms. Gardner's family law attorneys and other attorneys she has communicated with. Presumably, had a true taint team been assembled to review the substance of communications as opposed to targeted searches for phone numbers and email addresses, these communications would have been identified. Yeah, this sounds overbroad. Detective John saw all contents on Ms. Gardner's Google account from 11/1/2021 to and including 3/27/2023. This included email content, including deleted emails and draft communications, voicemails, documents, private messages associated with Ms. Gardner. Though the return for the iCloud warrant indicated the data was not received until May 1st, law enforcement was in possession of her iCloud by April 26th. Interesting. On that date, all these people circulated a copy of Ms. Gardner's iMessages from the iCloud covering dates from at least January 10th, 2016 through August 24th, 2022 via email and divided it up for review. So that's the exporting that I've been complaining about a whole bunch. Notably, S.A. Nazario was not included on the email, had not reviewed these iMessages, and were unaware that they were circulating this data. Which again, it sounds to me kind of like they're not really blaming S.A. I wonder if they're going to include, you know what it is? I wonder if they're hoping he's actually going to be a good witness for them, because they seem like they're not really blaming him. Remember earlier, it was like he had good intentions, but like it wasn't his fault. They didn't provide him with the training. They didn't tell him what to do. You know, they made him do all these different things, and now he's a witness. And again, in this case, they didn't send this over to him, even though he's supposed to be the taint team. On or about May 11th, 2023, Butler contacted Stifler because she had reviewed the iMessages containing attorney-client communications. It'll be really interesting to hear what happens, because we know where they're at from what happened before. That was mostly pertaining to Mario's stuff, as far as what's privilege and what's attorney-client and what's not. It'll be really interesting to see what happens with this one. Okay, they completed the filter review. That's going to come up right at this time. Counsel has only verified the IRS. Butler reviewed the iMessages. Presumably the others did also. At some point during the summer of 2023, IRS Butler received Ms. Gardner's Google return from Detective Johns with all the data, including messages and emails prior to S.A. Nazario's taint review. So here's the case law. You know, I almost kind of want to get to go to the hearings, because they're going to argue that. I'm really curious what they're going to say, because I feel like we got additional information, right? The hearing we watched last night, there was additional information, right, from versus what we got from reading the initial motion from the defense and then the state's response. Okay, but let's just see here. Interesting. So the improper use of a taint team in this case contravenes foundational principles of the attorney-client privilege and the Sixth Amendment right to effective assistance counsel. First, even if composed entirely of trained attorneys, a taint team may, quote, make errors in privilege determinations and in transmitting seized materials to an investigation or prosecution team. Yeah, I mean, I think this all makes sense as far as the potential issues that are there, but they're citing the case law. Again, they'll argue this in the hearing. This was also cited in Mario's motion, right? The purpose of the attorney-client privilege is to ensure full and frank communication. We covered this. We've talked about that at length. And this is where you get into a Sixth Amendment problem. And there we are with the Sixth Amendment. As I had said from the very get-go, I was like, this is going to get into Sixth Amendment, isn't it? Put simply, the filter protocol authorized government agents and prosecutors to rummage through the email files in disregard for the attorney-client privilege and the Sixth Amendment. And that was citing another case. Wow, look at this, though. Prior to ASA's Stifler's conscious and intentional meddling with the taint process. Bringing it. Wow. The taint team, and again, they put it in scare quotes every time, which is hilarious to me, consisted entirely, right. Well, you know what? Good point. A taint team, right? And it's just one person. Yeah. A non-lawyer with no prior experience or training in serving on a taint team. Well, that's what are we doing? What are we doing? And then again, initially he was involved in the forensic examinations of her devices. So now he's part of the prosecution team in this case. Oh, yeah. So here's his testimony from a deposition. Without having any training and having never done one before, if you came across a document, email attachment, map, letter, anything you can imagine, and you were uncertain as to whether that was obviously a confidential communication between a lawyer and the client, and perhaps not, what was your training, knowledge, and understanding as to what you should do and who you should go to. If I had any questions, I'd reach out to the prosecutor, and that would have been Miss Stifler. You've got to be kidding me. You've got to be kidding me. Then what's the point? Just let her do it, right? Fucking hell. Question: there was no filter between you and the prosecuting agency in which we were make attempts to make sure never was in possession of our communication. You would just ask the very person if that was confidential. Answer: I know that initially I reached out to either Detective Johns or Detective Lamont about, I had a question with regards to, whether it was a message or a document that I was able to recover, to speak to her. And then after like the second or third request, she said just for me to reach out to her directly, which is what I did. Fuck. That's why she's going to be a witness. As instructed, he asked ASA Stifler to review attorney-client communications. So that's why. This is where you know what? We heard in the last hearing that we watched last night that new information had come to light within the past week. I wonder if that's what this is, because they deposed this SA Nazario, because this is like hardcore. She literally was involved in the process. 2 or 3 times. Once is too much, right? Shouldn't happen once. That she was involved in assessing this information. Wow. At least on one occasion, at least one occasion concerned IRS Butler's discovery of a file found within Miss Gardner's iCloud return. IRS Butler candidly admitted in deposition that she should not have seen that particular message. Jesus Christ. ASA Stifler welcomed the opportunity to determine whether communications were or were not covered by attorney-client privilege. She intentionally became a member of the Taint team in violation of the parties. Jesus Christ. Oh boy. She took such action despite knowing that the Fourth Circuit SAO was an interested party in the pending dispute. Dismissal of the indictment is required due to prosecutors and law enforcement engaging in outrageous government conduct and prosecutorial misconduct, which violated Ms. Gardner's constitutional rights to due process and effective assistance of counsel. Rule 3.190B provides, quote, all defenses available to a defendant by plea other than not guilty shall be made only by motion to dismiss the indictment or information, whether the same shall relate to matters of form, substance, form or acquittal, form or jeopardy, or any other defense. Generally, a motion to dismiss must be filed before arraignment. However, Rule 2.190C provides that a motion to dismiss based on fundamental grounds may be filed after arraignment. The government violates the fundamental rights of due process when its conduct is, quote, so outrageous that due process principles would absolutely bar the government from invoking judicial processes to obtain a conviction. So the word outrageous, he actually took from other case law. Actions by ASA Stifler and law enforcement amount to outrageous government conduct which shocks the conscience. Again, that's going to be quoting something from case law there, in violation of Ms. Gardner's rights to due process and the effective assistance of counsel. Quote, cases finding a due process violation based on outrageous government conduct have one common thread: affirmative and unacceptable conduct by law enforcement or its agent. That's from Bist v. State, and that's Florida. And they're going to have some more, wow, lots of case law. I mean, I think it goes without saying, right? This doesn't surprise me. Here, outrageous conduct by law enforcement and the prosecutor clearly shocks the conscience. Not only did ASA Stifler willfully violate the parties' court-ratified agreement, but law enforcement applied for subsequent search warrants, presumably with this assistance. So here's the other issue, okay? They obtained additional search warrants. So what that means is that there could be information learned from stuff that should have been privileged. And based on the new information they learned that they should not have learned, they subsequently filed more search warrants. That's fruit of the poisonous tree, right? Just like in Koberger, different issue, but still fruit of the poisonous tree. It's like now this whole thing, that's why they're like, you need to just dismiss, you can't prosecute this, you need to throw it out. Remember with Mario, they weren't like, you need to throw it out. They were like, we need to get rid of the prosecutor and the whole state attorney's office. Here, they're like, you need to throw out the indictment. That's what they're saying. And I did mention last night, that there could be some differences between what happened with Mario as it pertains to attorney-client privilege and also what happened with Shanna, because again, there was such a difference in, of time from when they were arrested. And also they have different devices and different things going on, right? So in other words, it looks like what they found with Shanna especially here, for example, right? The additional search warrants based on what they learned, that for her specifically warrants a motion for a dismissal of the indictment, whereas with Mario's case, the attorneys weren't really asking for that. Oh dear. Oh man. Well, these include the February 22nd warrants for Ms. Gardner's Apple iPhone and app. So they're getting into the subsequent search warrants that presumably were made based upon new information that was privileged, right? Or should have been privileged. Okay, February 22nd warrants for her Apple iPhone and Apple iOS. More egregious warrants are the April 3rd warrants for her iCloud Google accounts that seemingly attempt to circumvent and did circumvent S.A. Nazario's review. Because of the extensive nature of the warrants, undersigned counsel has reason to believe that ASA Stifler personally assisted in writing the warrant applications. There can be no doubt that all these state actors knew they were intended to seize the very same messages, emails, documents, voicemails, and other data that were on the devices pending S.A. Nazario's filter review. Knowing they were looking at the very data that was the subject. So again, they're referencing the hearing that we watched, right? Knowing that they were looking at the very data that was the subject of the February hearing, these people all proceeded to divide and review her iMessages. So what we're learning is that after the hearing we watched last night, it got worse. It got worse. And especially it sounds like as it pertains to Shanna. Okay. More bad things happened. They continued. Wow. You would think that, I mean, of course, right? You would think that now that this is happening and after all the arguing and after the hearing and like after now that they know that like this is a problem, we can't do this, like it's a big problem, right? But like they keep doing it. That's insane. Wow. S.A. Nazario was notably excluded. Again, they keep leaving out the one Taint team, dude, the lone Taint team, notably excluded from this process and was unaware that the unfiltered data was being circulated. IRS Butler testified in deposition that there was no indication that the iCloud return had been run through S.A. Nazario as part of the team. Jesus Christ. So the iCloud return did not go through the Taint team process. In fact, S.A. Nazario had not completed the Taint process on the iCloud return until approximately 3 weeks after, law enforcement began its review. S.A. Nazario testified in deposition that at some point, IRS Butler contacted him to request Taint review for data that was, quote, not pertaining to any of the devices that he examined. Detective Lamont advised him, quote, not to worry about the Taint review that he was being asked of by the ATF, that it was going to be handled in a different way. Law enforcement gave S.A. Nazario this instruction despite his clear assignment to ensure that none of his review data was turned over to law enforcement or prosecutors before being filtered for attorney-client communications. In effect, law enforcement and prosecutors willfully and consciously circumvented the parties' court-ratified agreement and the use of a Taint team. They should complete disregard for that agreement and the sanctity of attorney-client privilege. As demonstrated above, prosecutors and law enforcement engaged in prosecutorial misconduct and outrageous government conduct which shocks the conscience in violation of Ms. Gardner's fundamental rights to due process and the effective assistance of counsel. Accordingly, dismissal of the indictment is warranted. There we go, right? Dismissal of the indictment is warranted on fundamental grounds under Rule 3.190B. Alternatively, now we're getting to what Mario was asking for. Alternatively, disqualification of the Fourth Circuit State Attorney's Office is required. So this is all what we already heard about a lot of that hearing. The actual prejudice is something more than an appearance of impropriety. Ms. Gardner is not required. Oh, so they're disagreeing. The state has been saying they have to show actual prejudice. They're interesting. Ms. Gardner is not required to show actual prejudice. Oh boy. So remember, we talked about this last night, right? Remember I was talking about the 3 prongs, that this is what we heard from the state. And this is what we heard at the hearing yesterday. This is a new argument, but potentially because there's new information that they have had since then. And yes, Baez don't play for sure. That remember what we've heard so far was like they had to have, it had to be privileged, right? They had to have reviewed it and they have to intend to use it. And it has to prejudice. I guess there's really 4 things. I guess maybe I left out the privilege part because it kind of goes out saying, but it has to have prejudice to them. So it has to be prejudicial. So but that was what we heard. So now this is a completely different thing. Ms. Gardner is not required to show actual prejudice. So in Castro v. State, Florida Supreme Court held that the state attorney's office should have been disqualified where the lead prosecutor in the defendant's retrial discussed pending motions with the defendant's former, this was cited, I think, in Mario's motion. Right. Okay. No, we read all these. We read all these. But what's interesting is that I don't think Mario made this argument, but he did cite the same case law. And I remember State v. Martinez. We actually read about that last night. ASA's Stifler's egregious infiltration of the Taint team constitutes substantial misconduct requiring disqualification of the entire Fourth Circuit State Attorney's Office. ASA Stifler's misconduct extends well beyond a mere appearance of impropriety. Yeah, a lot of this is argument they'll be making in the hearing. Here, although the state initially argued that Miss Gardner's co-defendant failed to right, this is what they said. This is what they said in their look, they're actually citing the motion that we read yesterday. So here, although the state initially argued that Miss Gardner's co-defendant failed to demonstrate that the prosecutor either personally reviewed prejudicial information or that the prosecutor provided prejudicial information to anyone else in the state attorney's office, subsequent discovery has demonstrated otherwise. This is the new information coming to light. Wow. ASA Stifler was directly informed of the contents of the privileged communications through IRS Butler and SA Nazario. This is not a mere appearance of impropriety. Rather, ASA Stifler's conduct is patently improper. In its response to Mr. Fernandez-Saldana's motion to disqualify, the state incorrectly argued that the 4th District in State v. Martinez held that information obtained from the prosecutor listening to that's the bit about the jail calls. This is, however, a misreading of the Ms. Martinez court opinion. The trial court in Martinez found that the lesser sanction of disqualification of the individual prosecutors would not suffice because the recordings were heard. Interesting. So they're pointing out a problem that I don't even know that Mario's attorneys caught, that the state misinterpreted or misread according to, it's as alleged by Shanna's defense that it was a misreading of the opinion. This is why you shepherdize people. This is why you shepherdize. This language was not a statement by the Fourth Circuit determining that neither disqualification or the individual prosecutor or the entire SAO was required. Rather, this language was the trial court's reasoning as to why it granted the greater sanction of disqualification of the entire SAO. Interesting. In other words, the trial court was simply explaining why the lesser sanction was insufficient to remedy the individual prosecutor's misconduct. Interesting. In addition, the state relied on Megs in and for the Second Judicial Circuit, blah, blah, blah. Let's see. They're saying in this case, it was not required because the prosecutor with the disqualifying interest was not the actual prosecutor in this case. Thus, this case is distinguishable because ASA Stifler, the prosecutor with the disqualifying interest, is, obviously, what the heck? Why would you? That's crazy. They would rely on that. That helps them. In addition to disqualification of the Fourth Circuit State Attorney's Office, this court should suppress all of her Ms. Gardner's iMessages regardless of the source. I don't think that's going to happen. Let's just see if there's anything interesting in here. Here, suppression of all Ms. Gardner's iMessages regardless of the source is likewise warranted as shown above. ASA Stifler engaged in prosecutorial misconduct that was substantial misconduct at best and outrageous government conduct at worst. The Fourth Circuit SAO expressly agreed that no one from the prosecution team would ever see the attorney-client communications. This conduct cannot be described as a mistake or honest disagreement of opinion, but instead demonstrates a clear lack of concern for Ms. Gardner's rights and the Fourth Circuit SAO's obligations to this court. In addition, ASA Stifler's actions, in addition to ASA Stifler's actions, law enforcement also engaged in outrageous government conduct in efforts to circumvent the parties' court-ratified agreement and the Taint team's, again, in scare quotes every time, review of Ms. Gardner's iMessages before they would see them. Suppression is appropriate and proportionate in this case to remedy the clear violation of her constitutional rights and to serve as a deterrent. I love a wherefore clause. Wherefore, Ms. Gardner respectfully requests that this honorable court enter an order dismissing the indictment as to all counts. Alternatively, Ms. Gardner requests that this court enter an order disqualifying the office and granting. So the first thing they're saying is dismiss the indictment. Second, just disqualify. What's so interesting is how with Mario, it was here's your two options. Get rid of the prosecutor, get rid of the office. I knew that because they're starting out with dismissing the indictment, I knew that they weren't going to give that other one as an option. So they're like, here's your options: dismiss the indictment on all counts, or if you're not going to do that, then you will settle for disqualifying the whole office. But what they're not saying is just the prosecutor. And I'm not surprised. I figured it would be like this. This is what I figured, because you know why? Because right here. Because right here. That's why. Like Flash fan said, Baez don't play. It's just he don't play. So let me find real quick. Which one is first? Hold on. Let me find the right hearing. Okay, this is the next one. This is from March 25th. Okay, so, and when was, I know you guys can't see it yet, but that's fine. So when was this filed again? Let me just see. All right, so this was on March 1st. Okay, the document that we just read. So the next hearing is March 25th. Well, there's probably some in camera, but of course we can't see that. So this is the next hearing on March 25th. So that's what we're going to get into next. So let me unshare, reshare, unshare, reshare. Okay. Is this the right one? Wait, hold on. Yeah, this is the right one. Okay, let me just start it over. Okay. Why are we pausing it?
We're here, the state of
Okay,
Florida filed
cool.
a motion for clarification. So I reviewed this case motion for clarification. Ms. Rodney. Okay.
It has to even matter. I have a feeling you're about to say it. We also filed a response.
I did see that.
By the way, I added Judge Kite to the thumbnail. I'm going to go ahead and put this on the record that I don't see how the prosecutor is not disqualified. I doubt it's going to be the whole office, but even just because the prosecutor, we already know she's going to be called as a witness, it's done, because you can't be a witness in your own case. Like that is, I mean, we're, that's Carrie Morrissey, right? But that was a whole different reason. And but it's like at that point, you're like, yeah. But, that I just wanted to say, my thought is that there's just no way around it, and that this prosecutor is going to get pulled off the case.
Can you just go ahead and have a seat? Or do you need right lighting? Okay.
So doing them one at a time. Oh, wow. Yeah. Oh no, they're bringing her in as well. Yeah, I went through all of the it's not easy to get all of them. You have to go through at least because they all have like the same exact title, right? You can't just like search for it and find all of them. You have to like literally go through in chronological order and scroll and like look at every single video. Like, well, this is what I did, right? For the channel that covers all these, but I had to go to all of their live streams, and you have to just like look literally at every single thumbnail and every title and find them. And it is easy to miss for sure. But to make sure I didn't miss anything, I went through it like 3 times. Like I double checked it twice, even just last night, to make sure I had all of them, because of the fact that like it gets confusing, because on the docket there's some hearings that are on there and they're in camera, right? And I'm like, oh no, did I miss one? And just to be sure, I go through it again. So yeah. Okay, well, I'm going to go forward a little bit because we're not getting started yet. Here she comes. Here she comes.
All right, good morning to you all. You all place your appearances on the record.
One thing that I think is interesting is that Mario's counsel did not get him, approval to wear street clothes, and hers did. I am shocked about that. Like, I would have thought that his counsel would have him wearing, civilian clothes. That's so common, like everybody does that.
Good morning,
All right, thank you. Good morning to you all. We are here.
Having said that,
Stating a following motion for clarification.
I will say, having said that, could that work out in Shanna's favor? I believe it. People might say it could, because even though what the public thinks shouldn't matter because jurors will be voir dired, I know that people would probably say something like, "Well, if you're reading into this the way that maybe the public would, right? Like let's just say you're not a trial watcher. Let's say you're just a random person, public, and you see these 2 people. What would you think? You would think she's not in custody. You wouldn't even really know what's going on, but you would think he's the bad guy, right? Like if you're one of those people, you would see them 2 together and you're like, oh, he's the bad guy, she's not. Now, clearly, that's not like Shanna's defense team can't keep Mario's defense team from getting him, approval to wear civilian clothing. They wouldn't be doing that unless they were severed, and then they were like it was going to be a different strategy where they're like going to throw each other on the bus. That'd be different, but they still couldn't stop that from happening. So I think it's like his defense team just isn't doing it, or I don't know. But I think it does actually work against him, right? And for her, if anything, I do think it should be. I do think he should be able to wear civilian clothes. I mean, every case you see that, so. It sucks for him, really. Yeah. Right.
Ultimately, prejudice has to be part of the equation in deciding how to rule on defense motions. And the court is not going to know what prejudice is. I don't see how the court would rule on the underlying motions. I understand why the court wanted a different court to review the alleged client privilege information. That makes sense. But then if the court is not going to know what that content is, it puts the court at a disadvantage.
Now, I will note, I don't think that lady is ASA Stifler. And on the last one, ASA Stifler was arguing. I mean, I think this is interesting, right? It looks to me like, again, if that's her, she's not speaking. But my point is this: usually you have the same attorneys that argue the different motions, right? As they go through, when it's the same, motions were on the same type of issues, right? So the fact that now Mr. Mizrahi is arguing instead of her, that is very telling. And that's something that the state would have made that decision, potentially knowing that what was going to happen, which really is interesting, right? It's like, there's no way around the fact that they fucked up. Like that's just, but it's so wild to me. Again, they did all this stuff after the last hearing, knowing that there was going to be scrutiny, knowing that these motions were being filed. Like, what were they thinking? They did worse stuff. I just can't wrap my head around it. Like, what the fuck? Was she trying to get kicked off the case? I don't get it. I just don't get it. It's like, let me just do worse than I already had done. Like, I don't understand. But I think she probably isn't even in that courtroom, and that would be appropriate. And that the state making that choice is a huge sign, right? Well, yeah.
And then, Mr. Dresser, you default response.
I mean, I don't think there's any witnesses in the hearings until, from what I went through, it looks like there's 3 hearings before they have the evidentiary hearing. The evidentiary hearing is when they have witnesses. So that's a couple hearings away. But I think even at this point, she shouldn't be involved. I think she should be get rid of her.
He did not follow.
Who's done.
We did not, but we opposed the state motion.
And again, the reason they would do that is because, remember, there's all these motions also pending to disqualify the whole office, right? So if you've got a prosecutor that you've now it's like there's no way around it. She's done, like she's compromised. You know what I mean? The first thing you need to do is get her away from the rest of the office as it pertains to this case, right? Because you don't want to then contaminate the rest of the office, because these motions are currently they're pending. And so that would be why you would say, nope, we can't have anything to do with you because we want to still try this case.
And so, Mr. Dreiser, I enjoyed reading the whole last break on this. I thought we had an agreement, and I'm going to start just first with Hernandez. Okay?
Unless that's her, I will be shocked. Is that her? No.
In the pleadings, Mr. Dreiser, I always thought it was 1, but you're saying it's 2.
Oh, that's Judge Taint. Never mind. That's Judge Taint. That's Judge Taint.
It's 2. One was sort of the feature of what the state and I had talked about, but as
it was called confidential communication. Both of them.
Both attachments are called confidential communication. What had happened was, in discovery, we had learned the state had always acknowledged they were in receipt and had looked at one, intended on using it, had looked at the other, or had been made apprised of the other, did not intend on using it, but it was in their possession. We learned that in discovery, both of those attachments labeled confidential communication, one had a typo, confidential communication, just an extra O. And they were emailed directly from Lindsay Butler to Ms. Stifler, and there were text messages and communications about those documents. Those are part of all of the other emails that they just say they had not seen, but they uploaded to Next Point, and we learned that they had access to really the entire time. Even Ms. Butler had access to them.
Okay.
So those are the 2 that are the documents. And I'm not sure if this is what you want me to respond to, but I find this motion ironic that at the last hearing, I suggested to this court, you could do everything to avoid this issue if that's what the state wanted. I even waived any kind of recusal argument that you would see. What we are arguing is confidential communications, attorney-client privilege stuff. And the state didn't want to do it that way then. The court didn't want to do it that way, which I was fine with. I understand why the court did it the way you had done it. And I just want to say, you had told us back in December what your plan was, and you have never deviated from that in chambers. From the moment we filed our motion, you said, this is what I'm thinking I'm going to do. You've reiterated that at almost every pretrial. So for the state to come in today and say, just kind of out of nowhere, we thought of this, I don't find that to be a credible argument, because they've had months to think about the procedure. And then at the last court date, you could not have been more crystal clear with us. You said, we have 2 documents. We have an agreement as to how we're going to proceed. I mean, you were baiting us to give you alternative suggestions or tell you that we aren't in agreement so we could iron it out. And it could not have been more clear as to what you wanted Judge Foster to do. And even, you may not know this, but when we got to the Judge Foster turnover, is really what I call it, wasn't really a hearing. Judge Foster we had prepared just the 2 documents, and we had done blackout copies and regular copies for the court. And the order, Judge Day's order, was somewhat unclear as to whether the emails, I think it was the emails that referenced the documents, but the state was like, you should read all the emails. So I ran back to my office, I blacked out all of the emails.
All what emails?
All 60-something emails, because I thought we had agreed on just the 2. But Judge Foster is now reviewing all of the confidential communications, all of the emails, and the 2 documents, really, which wasn't, I didn't have any objection to that. That's what the state wanted. I figured, let's get it over with. Let's move this case forward. But even I thought at that hearing, we kind of got put on short notice as to what the state wanted. But either way, we complied. And then shortly after that, Mr. Nazario reached out and said, we want Judge Foster to review everything. And most importantly, and Mr. Crody and I both agree, I don't think Judge Foster has jurisdiction to make a ruling in this case. He's not a circuit court. He was appointed as a special master to review documents, not to make decisions in the Fernandez-Gardner case. And I think that's
right. And I was going to say, so as far as that goes, I was going to say, so remember, a special master can be appointed by a judge, but it also could be a judge. And here's the distinction, okay? What is different? So the difference is that the special master typically, right? Again, they well, again, they have a different role as it comes to like depositions, like we talked about earlier. But for something like this, it's like a taint attorney, right? Something like that, right? Where they don't actually have to be an attorney, but they're supposed to be. It's a third party, neutral, to come in through, review documents or assist in mediation. You know what I mean, and do that, right? And the judge would assign them and tell them what they need done, and they'd be appointed by the judge. When the difference, right, like for this other judge person, right, that they have, judge person, I forget what his, Judge Preston, I forget what his name was, but anyway, the other judge, the reason they would have a judge instead of just a regular special master who's maybe not even an attorney or a judge, right, the reason they would have a judge is because would be in order to rule, right? So there's two things that have to happen, right? Because Judge Kite doesn't want to look at any of it. She doesn't want anything to do with it. So the two things have to happen. They have to have someone properly just say, this is privilege, this is not privilege. This is, and put it into two piles, right? Judge Foster, thank you. They need two piles, right? Then after that, so that's like the basic thing where you just look at it and put it in the piles, privilege or not. After that, then there's all the other prongs we've talked about, right? Is it going to be used at trial? Is it prejudicial? Who read it and who didn't read it? And now we're getting into the actual issues that they're arguing about before Judge Kite, which is, evidentiary issues, really, right? Where you need a judge to rule on it. But that's something that Judge Kite can't do because it's still concerning this potentially privileged material. So essentially, that's why there's been talk of a Judge Foster and a special master, because they kind of would have to, now, while Judge Foster could also perform the role of a special master, normally you wouldn't have a judge do that, right? Because you want to use the judge for doing things that only judges can do, if that makes sense, right? That's why there's been talk of both. And even in looking at the docket, you can see both. You can see special master, and then you can see Judge Foster. And I remember when I was just scrolling through it, I was like, what's the deal? Why do they have both? But it makes sense now what the issue is. And especially knowing that Judge Kite isn't going to be ruling on any of these things, it makes sense that you still need both things done. But what he's saying is that, what did he say? He said he didn't think they needed the judge. Let me just back it up a second.
We want Judge Foster to review everything. And most importantly, and Mr. Crody and I both agree on, I don't think Judge Foster has jurisdiction to make a ruling in this case.
Okay, great. So that's important, right? Because of what I just described. He's saying that he doesn't think Judge Foster has jurisdiction to make a ruling. If that's the case, then what that's kind of saying is like, Judge Kite, it has to be you. Now, if I don't know what's going to happen. If that argument is sound, and if that's what ends up happening, then what they would end up with is they would end up with the special master to just, again, the two piles, but then Judge Kite would rule on what's coming in and what's not coming in. So we'll see.
Circuit court, he was appointed as a special master to review documents, not to make decisions.
So Judge Kite weighed in on this on the last hearing, and I thought it was very good. What she said was like, she doesn't want to be seeing things that won't be coming in at trial. Like, and that's, that's smart. That's smart because she doesn't want to make herself a witness, right? I mean, it's just, it doesn't want to cause any issues that could be reversible error in the future. She doesn't need to see any of it. She just needs to be seeing, like, again, once it's passed all the initial tests and like all the initial filters, right, to where it's not provable, she'll rule on what's coming at trial. But like the problem is like this stuff hasn't met that threshold yet because it's still all about, is it privileged or not? Is it privileged? And so that is smart, right? That's why you always have third parties review all this stuff. So that way it doesn't end up even giving the appearance of impropriety, right? No appearances of impropriety. That's why.
And as part of the case, and I think
Okay,
that's
well, let me stop you there. So from my understanding, I always thought, and I'm just sticking with Francis, pray, just bear with me, okay?
Yes, sir.
All right. Did the state believe that, I thought we were very narrow in what Judge Foster was actually going to review. And I thought the state was indicating through your last response.
Right, they were. The state's changing it. That's what's happening.
That the state, there wouldn't be any need for Judge Foster to make any type of prejudice.
Okay, so here's what she's saying, and what she's saying is matching what the defense is saying. That, and it's accurate. We watched it last night. What they agreed at the hearing is that what Judge Foster would review would be very narrow. It was just as it pertains to that folder, the confidential communications folder. That was it, right? Because initially they were all in agreement, and on all the other stuff that that was the thing that was really the thing at issue. And what she's saying is that having it being so narrow, he wouldn't have to rule on it. And remember, the reason I'm mentioning this is because the defense just said there could be an issue with jurisdiction, right? Now he can't rule on it. So now the state is throwing a monkey wrench in the whole thing by saying we want him to review everything. And what Judge Kite is saying is, well, that's not what you said yesterday. I thought we were not, well, for us it was yesterday. For them it was, I don't know, a couple weeks. But that's not what you said before. And I thought we were all in agreement, and now you're saying something different. And what you're saying would require him to have to make a finding.
Or because the state was saying you did not have access. The state was agreeing that these two documents you have access to, that your alternative view is that it is evidence, it is not attorney-client privilege. So.
Right, in analyzing both defendants' motions, and we're trying just to say to Mr. Fernandez, the allegations are not just about those two items that the state is. So
let's stick with Fernandez for now. I've got a different set of questions, because when I did the initial order, I didn't have Ms. Gardner's motion and what was going on.
Right. Right. And that's the thing, is that motion came in a couple weeks after the hearing we just watched last night, and they learned new information.
I'm sorry, even ask Mr. Fernandez, the allegations
are
the improper handling of.
Ew, look at the way he did his head with that. Oh my God, that is so offensive and just condescending. Watch.
I'm sorry, even ask Mr. Fernandez, the allegations are the improper handling.
Wow. No. I don't think this is not the approach you should be taking. The approach you should be taking is like, what can I do to make this right? I will, can I give you my arm? Like, this is crazy that this is what he's doing, because the allegations here are so serious, especially, like I said, especially after it was already talked about, especially after they had a hearing, and then they did it more and they did it worse after. You know what this is this is reminiscent of YSL. And part of the way that, part of the reasons why Judge Whitaker, rightfully so, was like, yeah, we're gonna just try to nip this in the bud, is because like those attorneys, what they kept doing was they would get scolded for something and they would just continue to do it, and they would do it worse. And then they would, and it was like, there was no repercussions. It was like, they were just getting away with everything. And like, no one was stopping them. It was insane. And, what you usually see is if there is any even whiff of like prosecutorial misconduct, even if it was inadvertent, the prosecution is like, let me make this right. Blah, blah. I mean, because like, this is crazy that you're like doubling down and like doing it more. And then to come in with an attitude like this in front of this judge, when this judge has just said, hey, you're changing what you agreed on. Like right now, this prosecutor is in hot water from everybody, right? He's in hot water from the defense. He's in hot water from the judge. This is not, I don't think, the approach you should be taking. Like, you should be groveling, I think.
Even if unseen by
wow.
the state of Florida, rises to a level that the court should remove the state of the attorney's office from the case. That's in Fernandez's motion. So the prejudice has to be part of that. And I just
these documents, these two things labeled, I thought the state court was saying this is evidence. So the case law is that there has to be
I don't know.
Inadvertently.
I don't know about that. I mean, are you saying as it pertains to literally what the issue is here in this case, or was there something else that happened? Because like, as far as what is going on here, so far, the prosecutor who's made the biggest, potentially sanctionable actions would be ASA Stifler, right? Because she's the one who did all the stuff. I mean, so I don't know, but I don't know if there's something else going on separately with Mr. Mizrahi. Again, I'm not looking ahead. But ASA Stifler, I don't know. It depends on what happens, right? If they go through all this and they find that the allegations are true and that she knowingly and willfully, violated attorney-client privilege and looked at that information and then used it for further search warrants, that's a big problem, and there should be sanctions for that. But that would apply that was very specific to her. Like in the motion we just read, that was very specific to her. So yeah, let me back it up just a second to hear what she's saying.
Fernandez's motion. So the prejudice has to be part of that. And I just,
Well, that document, these documents, these two things labeled, I thought the state court was saying this is evidence. So the case law is that there has to be, if the state inadvertently gets information that is in fact attorney-client privilege, there has to be some type of mitigating scenario by the state of Florida, and that would be essentially a line. That is, the state board did try to mitigate anything. So you were saying it's evidence, it's not attorney-client privilege, and the case law seems to flow from that would be very decisive in what decision would be made. And I don't know why Judge Foster would need to make that. If you were saying you had access to it, full access, and you're saying it's evidence, Judge Foster says, let's say he rules hypothetically that it is attorney-client privilege, there isn't any need because the state has already said, I've had it, it was evidence, and the case law is like, for example, I can't remember the name of the case, but it was like jail calls where the state had it.
Nunez. It was Nunez, I think.
Before the qualification should look, right?
no, I agree that although case law may indicate as to those jail calls, I believe in this particular case with this particular facts, prejudice has to be part of it. Because even if these are potentially attorney-client privilege.
What did I say? What did I say? That this was what this is why this, and this came up in the, it didn't come up as a separate thing in Mario's, but it came up in the one we just read from Shanna, where remember, they're going to argue over it. Does it have to be prejudice or not? The state is saying yes. The defense is saying no. Remember that bullet point that we saw, it was like, Shanna does not have to show prejudice. And I was like, oh, that's a new argument. That's a different argument. So this is a huge matter of law right here, right? Does there have to be prejudice? Or is it just, remember the different prongs. Is it just, was it privileged? Did you read it? Are you going to use it at trial? Or are we adding, or does it have to also be privileged or prejudicial as well? And he's changing his tune based on their argument. Now I say he, again, it was ASA Stifler arguing this before. But yeah, I mean, this issue right now, I mean, ASA Stifler is the most on the hook for what's gone on with the prosecution because she's been the lead and she's the one also who was looking at all the stuff. So again, like the smallest remedy that they are asking for is removing her, literally her, because she's the one who did all these things. So far, I don't know if he's done anything else, but he's not been named or even mentioned in any of these motions. But the problem I have is like, even though he didn't screw it up, he's the one that has to fix it now because it looks like ASA Stifler is no longer, she's just gone as she should be because he's now arguing it. So in other words, whatever she did to fuck it up, it's his job though, even though it wasn't him, it's the state, right? They're both representing the state. It's his job now to grovel and be nice and to do all the right things, even though he didn't mess it up because he has to fix her mistakes, but he's doing the opposite.
The contents of what was looked at are not communications between a lawyer and a client, like a jail call. So I don't think that just because
Judge Kite's face.
Judge Foster rules is attorney-client privilege of the case law applies. I disagree because the content matters. It matters us.
She's like, I'm not buying this at all. That's what I think.
The allegations that the defense has made goes beyond that. It doesn't just talk about the documents.
Why did you ask him to review the 16?
Yeah.
Because it's part of the defense motion. They have said that even though the state never saw these things, they should be dismissed from the case because they had access to it and put it on a
But
other people had access.
What is wrong with him? They said at the last one that they weren't going to use it, right? Y'all remember? They were like, we're not even going to use it. This is in reference to all the next point stuff. They're like, we're not going to use it, so it doesn't matter.
But the state's defense always was that you never accessed it.
Correct.
Right.
Correct.
So why is he reviewing it? If no one accessed it.
Right. Sorry.
Mr. Dreiser.
Sorry. I got, so that's right. They never, I think they also said they weren't going to use it. Or no, sorry. What they said was they didn't see it, so they don't know if they're going to use it. And they don't know if it's privileged. But they said they never accessed it. But what she's saying, if no one accessed it, remember how they said they could prove it? Remember how they said they could prove it with the metadata? Remember that part? They said, she was point blank on that. We never saw it. We can prove it. And I kind of thought, okay, it sounds like that's a non-issue. It sounds like that's solved. It's just the only thing that issue is this confidential documents folder thing. But what is happening, dude, wow. What's happening now is because Mr. Mizrahi is now saying that he's requesting that, wow, this is crazy, that the other Judge Foster also has to look at this stuff. Well, she's saying, well, wait, hang on. Why, if no one accessed it, that doesn't need to be done. It only needs to be done if it was accessed. Oh man. So does this mean they actually did see it? I'm going to lose my mind. Because if they come in and intentionally lie to the court, which would have been like, that would have happened at the last hearing potentially. And they backed it, they put it in their motion. They said point blank. And they even said, if the state had bothered to come to us and ask for this data instead of filing spurious motions, blah, blah. Oh boy. Because what she's saying makes sense, right? She's like, why does he need to review it if you didn't access it? Oh no.
He doesn't want anybody to review it, and that's what he made that very clear. Like, and I wasn't under the impression that Judge Foster would be reviewing any of those things. I thought it was just going to be the two.
The reason why first of all, he thought he was reviewing it, and he's asked the parties, and the state said, yes, we agree you should be reviewing that. We don't know what's in it. Okay. But it could be, because based on their motion saying that we uploaded it to a cloud, the entirety of those conversations could be, hi, let's schedule a meeting.
There's the part of scheduling a meeting again.
And then the court can make two findings. One, that the state never had access to it, never saw it. And two, even if they improperly uploaded it to a cloud, it is de minimis and non-prejudicial.
This is where that whole thing again. They're trying to go for it's not prejudicial. It's not like even if it is privilege, it's not prejudicial, so it's fine if we saw it. You see what that you see the problem with okay. They wouldn't be arguing this unless they know that they must have seen this stuff. Because here's the thing. The reason you would make this argument is if you know you've seen stuff that's privileged, but you're trying to be like, it's okay that we saw it because it's not prejudicial. Does that make sense? Because if you did, like, again, going with what, if you know you didn't see it, it doesn't matter if it's prejudicial or not. It doesn't matter. You don't know what it is and you didn't see it. It doesn't matter. The only problem that we have here as it pertains to these motions is that did you guys, that first thing is like, did you guys see it, right? But the only reason you would then be making this additional, adding this additional prong of the prejudice question, right? When we keep talking about the prongs, the prejudice question, and that came up at the end of the hearing. That was like added on last. Because remember, I was like, oh, I have to reassess the prongs. Like that was kind of tacked on. Like, and I wonder if it's because Stifler was realizing that they were in hot water with this but she was still holding strong and doubling down that they didn't see it. Interesting. Oh my God, this is really fascinating because yeah, okay, I'm gonna back up a bit. This is really
okay.
And then the court can make two findings. One, that the state never had access to it, never saw it. And two, even if they improperly uploaded it to a cloud, it is de minimis and non-prejudicial. So you're able to make rulings on multiple avenues, not just one that you just didn't see it. Because the motion allegations go beyond the seeing of those items, they go to actually the mishandling of the items even if you didn't see it.
What's your response to Mr. Dreiser's, that he doesn't have jurisdiction to rule on
okay, the jurisdiction.
The, disqualification motion?
Well, I agree, that's why I filed the motion. I think that we in order to get from that jurisdiction. Okay. Or, I mean, maybe I didn't realize this the first time, the state is fine with the court ruling on the ultimate motion that you have to review everything. So, I mean, it doesn't matter to us what judge does it, but we think it should be the same judge.
This is very different than like a civil case, when a court would normally review attorney-client privilege as a problem, because a civil court doesn't have any type of sentencing power. I potentially would have sentencing power in this case, and that's why.
Yes.
We understand why.
And so that's an additional reason why she's like, I don't want to be involved. I don't want to be looking at any of this and be involved. Yeah. So wow. But also, yeah, I mean, that's, yeah, there's a lot of potential for things to go wrong for like reversal or just issues because the fact, just the evidentiary factor here. And again, like, yeah, I mean,
the defense is willing to waive it, we have no problem. The whole point of the state's motion is that it seems impossible for one court to rule on what the defense has filed without some knowledge, without full knowledge, of what the contents of the communication is.
Mr. Dreiser, do you have anything else to add?
I would like to add that this is just yet another example of the state of Florida not following the procedures that are set.
Yeah,
either
I
by
would
agreement
agree.
or court order in this case. This whole entire issue stems from an agreement that the state and I made at a pretrial hearing before my client was even arrested to make sure that our attorney-client privilege information would not be looked at. And then it got looked at. And access.
Yeah, I'm gonna check this right now. I mean, this is not about merits of the particular item. Okay, not checking.
Well, I just.
Wow.
I'm trying to get down to what will, I don't want to stay this case any longer than I have to. I want to get down to really the heart of what the dispute is so that we can move this case forward. And I tried very, very, very hard at the last hearing to narrow the issues for Judge Foster. When at the outset of this case, both sides were very clear there were terabytes and terabytes of information that are up in some cloud. And I did not want Judge Foster to look at terabytes and terabytes of information. I want him to look at the information that will help this court make a decision on the motions that were filed. So let me ask you this, Mr. Dreiser. What do you have to say? Like, I initially thought it was have you agreed to the 60 emails for Judge Foster to look at?
I was put in a scenario where it did appear he thought he was supposed to be looking at them. I think what he was supposed to be looking at is the attachments with the corresponding emails to those attachments. But I figured he was a special master, not making the ultimate ruling,
Right.
not going to share these.
There's that distinction that I was talking about again. That's so funny that this is coming up. And I saw this coming when I was like, okay, why do they have both? The distinction between a special master and the judge, right? Because let me back that up so I can show you guys again. This matters.
Looking at them, I think what he was supposed to be looking at is the attachments with the corresponding emails to those attachments. But I figured he was a special master, not making the ultimate ruling.
Not making the ultimate ruling. Again, there's a difference because there's some information, like for example, the 66 emails in the next point. The understanding after the last hearing was that everything needs to be gone through. Remember how it used to be called the Taint team, but it was just the one dude. Now they're like, that didn't work, so we're using the special master, right? So everything has to go through the special master, right, for this potential privilege. So all of that needs to be sorted. Again, think about the two piles. Is it privilege? Is it not? That's all they do, right? But then again, there's this next step after that is then there's certain things where there's going to need to be certain rulings made, and that's done by a judge. So when it came to the next point stuff, what was the understanding after the last hearing was that all that next point stuff was just going to be handed over to the special master to sort it into the piles, right? Whereas the documents, the confidential communications documents folder, that was a huge point of contention. That they need a judge. Kind of like we were talking about earlier with the deposition, right? Where we're like, they need help. There's matters. There's issues here, issues of law here, right? Of like, can it come in? Can it not come in? Blah, blah. Like evidentiary issue, like they need a judge to rule on it, So that's the point is like, that's why they had said, we're going to limit what Judge Foster has to do. So in other words, the special master would go through and look at all the, again, like the next point data, and Judge Foster would just make a ruling as it pertains to the confidential communications folder, right? But now with the state changed it. And so now we want Judge Foster to go through everything. And they're like, no, this is not happening. This is not what you agreed to.
Not going to share these with anybody else. So my client authorized me to get all of the emails unredacted to Judge Foster's review. And remember, and I'll move on from my historical gripe with this case, but I will say many times up until now, they have suggested that the 67 emails that they've never seen their privilege, their communications directly between me and my client and back and forth. And now, well, maybe they're not privileged, maybe they're just scheduled. The state just keeps moving the goalposts, and they're saying, you need to review them to determine the weight of the prejudice. It's prejudice. They have my communications. Everyone had them. They were
this argument.
They had access to them. That's not even in dispute. Ms. Butler had access to them. Everyone that was on Next Point had access to them. They were all on Next Point. And then it's just the two documents.
So I'm wondering.
I don't think once you.
So I'm wondering if this is ASA Stifler. It's just the shield's different from last time. I think maybe her hair is curlier. Is that Flash Fan? Do you know if that's her? I mean, I would assume it is. Although she just doesn't look the same to me. She looks different. But again, like she's not saying anything. But I don't even think she should be there. So maybe that is somebody else. I don't know.
Review Judge Foster's order, which perhaps we should hold this ruling until I'm not exactly sure what it's going to look like. I assume it's going to be a privilege law. It's going to say this date, this time, this email, privileged. This date, this time, email, privileged, not privileged, whatever he finds. And then at that point, it may be very obvious to you whether you can or can't make the determinations in this ruling. I see no reason with that information alone that you would not be able to make a ruling.
What I was really looking for and hopeful is that Judge Foster would review. He would determine if it's privileged, not privileged. Then I would be able to look at the metadata. That is, whether the state of Florida accessed certain files, whether the state of Florida, anyone accessed those files. If the state of Florida didn't, prejudice to me doesn't really matter all that much, but you're saying it does.
Well, I agree, it doesn't matter as much. That's totally clear. If we didn't see it, obviously prejudice doesn't matter as much. When we go to the defense motions, it does. Because they're alleging it doesn't matter if they saw it or not. Their motions say.
You're just saying this that it got uploaded.
Correct, because we uploaded it to the cloud. I think at that point, the nature of it, the court can make two rulings. One, the state.
I don't think that's what they're saying.
Two, even if they did see it and mishandle it and it was up in the cloud, that it is de minimis and non-prejudicial.
Okay.
And there are two elements, though, that the court is going to be faced with. There is case law that suggests what the standard is to dismiss just the ASA, where ASA is handling. So the court saying, well, Ms. Stifler was in possession of this. Emails went to Ms. Stifler. I'm going to remove Ms. Stifler and anybody.
This is like what I was just saying before about how like Ms. Stifler is like the biggest issue, probably, at least, you know, because there's things that just she was responsible for doing.
She worked with or, you know, shared that information at the time, but I'm not going to remove the entire office. That's one finding the court's going to have to make. The second layer is whether we dismiss the entire fourth judicial circuit and assign a new prosecutor, depending on how widespread that is. So I agree with the state that you have to know about access and what each person received, but it's a little bit more fine-tuned than that because there's kind of two entries for the case.
Either way, Stifler's off this case. I think that's, you know, been clear.
Thank you.
I don't know why
Mr. Cody.
she should not be there.
On the Gardner case, I had a different set of questions.
Okay. Oh boy. Oh boy.
And then amended the request for the special master to review. To me, your motion exposed more.
Yep.
And the way I remember it is that.
Yeah, exposed more. And like I said, this is where like they went even further with their fuckery in terms of what they did with Shanna's materials after the last hearing. And then again, remember the other thing that was different too with her, the subsequent search warrants.
There were devices. There was a Google Cloud, there's an iCloud, there were Google devices, there are iPhones that were then search warrants were served on that, not given to the Taint, not given to the Taint team. And then there was an email from one of the officers to Ms. Stifler, I believe, asking whether this was like return time.
Yep. And that was, you're right. So she saw, like, the other thing that is wild is that, like, they had said that to the agent dude, whatever was his name, Navarro, whatever his name was, the special agent. They had said to him that, okay, if you're not sure what it is, because remember, they didn't give him any training. If you're not sure what it is, here's who you can ask. And everyone who they told him he could ask already was a problem because they were all within the office, right? They're all like law enforcement or whatever. But then, according to the defense, Miss Stifler here said, no, don't worry about that. Don't ask them. Just come and ask me. So like come directly to me with this so I can tell you if it's privileged or not. Like what is going on?
Multiple communications with Ms. Stifler about whether or not these were
yeah. This is the type of shit I'm talking about. There's going to have to be some sort of sanction for this. And what we're seeing is it just keeps getting worse. So like, I don't even know what to expect because if it gets worse, I don't even know. But again, it's already so bad. And then on top of that, the information gleaned used for subsequent warrants. I mean, I don't know. I think she's looking at all kinds of problems with this, you know, and I think that there could also be potential, like, you know, technically there could be lawsuits for civil rights violations, you know? Yeah.
And my understanding is that what was served on the search warrant was then uploaded to some cloud, okay, and then that information was divided out among law enforcement, not the Taint team, not the Taint agent, I should say, and they were going to go through it.
So,
oh, did you hear her? Oh, good, dude. That is a signal right there. She was saying Taint team because that's the term that's been used so far, right? And saying it automatically. And so she was saying taint team, and then she corrected herself, and she did. She said taint agent, I should say. Ouch. If you're the state, wow. That's a statement. That is a statement from her. Like, how dare you? Like, they are the ones that named it taint team when it was one person, when they knew it was just one person.
Is that what?
Oh.
A little bit different. So you have next point over here, which was the first issue brought to the court's attention, where the what I would call the unredacted, or the information that had not gone through the taint team, was uploaded and accessible. Separately, in February of 2023, after the agreement to use a taint team was agreed upon by all parties, the state went out and executed search warrants on Google and Apple for cloud data associated with the accounts that were linked to those devices. Those returns were then given to law enforcement, who began reviewing them without any involvement of the taint agent. And the one that, well, we know that they were both reviewed. The one that we find to be most egregious is they took her text messages, her iCloud text messages, so her iMessages that come in the form of an Excel spreadsheet, and the law enforcement team emailed them around, divided them up, and said, start reviewing.
How many emails is that?
How many text messages?
Yeah, the text messages, whatever this is.
Hundreds of thousands.
Okay, and you're claiming that would be attorney-client privilege,
There-
or just some of them?
Some of them are, and we know that some attorney, at least messages between Ms. Gardner and her attorneys, were reviewed by the law enforcement team.
There was also some kind of call between your client and Hank Cox, is that right?
Yeah, there was a recorded phone call.
Where did that come from?
So we found that on the data from my client's iCloud, and that was something that we found. And we do not have any information based on the depositions that was reviewed by a member of the law enforcement team. But I'll be honest with Your Honor, we are still finding more attorney-client communications up to this day. I mean, there's just, as we discussed, there are terabytes and terabytes. There are hundreds of thousands of
And this is where I said it keeps getting worse, right? Fuck.
We've been sorting them. Not all of them can be clearly identified by phone numbers and things of that.
What did you give Judge Foster?
We gave Judge Foster that call, some text messages and some emails that we were identified between Ms. Gardner and her attorneys. I do want to tell the court that the access issue is only part of our motion. The gravamen of our motion is what we characterize in our motion as substantial misconduct.
Yeah.
And that would be the actions by the prosecution team. And we believe that
The thing is that Miss Stifler really tried to make it seem like I would say she did a pretty good job. I would say, like, I was, if you guys remember from what we've been covering this, I was like, oh my God, like, blah, blah, blah. But then she kind of did a good job in gaslighting, I guess you could say, in terms of really trying to make it seem like there's no way they saw that 66 emails. They didn't see stuff on next point. We can prove it, blah, blah. And she kind of did, and that, this thing's evidence is, in terms of the folder, it's evidence. It's not, blah. So she so in my mind, I was like, okay, like, I guess it's not really all that bad that what it seemed like. Okay, blah. But she does that, right? And then after, she goes and this is where the willfully and the outrageous misconduct comes in, because of the fact that after all this, she then takes these other steps. That's even worse, where she's like literally asking to see stuff that's privileged and doing it's like, it just blows my mind. Let me back it up just a second. And so this is right, because this is why, like, in other words, they almost got out scot-free on this, right? Like, and just don't fuck it up again. Do your job correctly. Don't be stupid. And like, we're going to move forward, blah, blah. But like, then they did the opposite. Like, why?
I do want to tell the court that the access issue is only part of our motion. The gravamen of our motion is what we characterize in our motion as substantial misconduct, and that would be the actions by the prosecution team. And we believe that includes the state attorney's office, it includes the ATF, it includes the Jacksonville Beach Police Department, that there was this agreement, and then they all willfully and intentionally sort of disregard it and start going through materials that they knew were carbon copies of the phones that they were told they were not allowed to touch. And so that is the gravamen of our motion and why we're asking for dismissal. Because we think that it's outrageous. We think that it was willful. We think that it was intentional. And we think that everyone knew what was going on and was okay with it. And that's not right. I mean, the attorney-client privilege is one of the most sacred privileges in court, and you can't just do an end around of an agreement to remove attorney-client communications from data. And I do think, Your Honor, that the state's motion is premature because we don't know what Judge Foster is going to write. We don't know whether or not it's sufficient for the purposes of the motions.
My problem is I don't know. So are you telling me that you still haven't identified all of what you need Judge Foster to review?
No, Your Honor, because I accept the state attorney's position that they did not review any of the
Interesting
attorney-client
Okay.
communications that were uploaded to next,
Okay.
at least the prosecutors. I accept their word with the court. Now, do I know what the Jacksonville Beach Police Department reviewed? No. I know what the ATF analyst.
He's accepting that the way I did after what they said yesterday, or yeah, for us it was yesterday. So, but again, that's why it's interesting that even with that being the case, they came in and tried to weasel that in with the whole thing about getting Judge Foster to look at it.
Reviewed because she told us. But I don't know what the other ATF agents reviewed or what the Jacksonville Beach Police Department reviewed as we sit here right now. But I also don't know that I've identified all of the attorney-client communications because there is so much data. And
Right.
some of those communications cannot be sorted by emails or phone numbers. We are finding them as we go along.
They're not done going through it. Discovery. That makes sense. That makes sense.
But I do agree with the court that, you know, if the state did not access them, then, you know,
Right.
that's a different.
But what he's saying is, it's almost, so she's asking, can you say for sure definitively this is all Judge Foster's review? What he's saying is, well, because we're still getting more discovery, we're still going through it, we can't say for sure because we're getting more stuff every day and it's going to take time. That seems fair. That makes sense. But what he's saying also is, but I take the state at their word that he doesn't have to go through the stuff. If they say they didn't review it, he doesn't have to go through it. So that's the best I can tell you right now.
That prejudice may not be important for that. Our motion, though, is primarily based on, at this time, the conduct by the state and its law enforcement team, which I believe the case law establishes they are all the state, especially when this was an active investigation involving the
Oh,
state
it does. It does.
from day one.
They are all the state.
And so the state, what I believe in the prior hearings has tried to do is say, well, that's them. We're not responsible for what the police do. We're separate from them. And I don't think that's what the case law says. And actually, I think the facts of this case will show that they were actively involved in every step and aware that law enforcement was going out and getting the iCloud and going out and getting the Google return.
They only do that when directed by the prosecution. There's no way around that.
Judge, since our motion primarily rests on the substantial misconduct, we believe that Your Honor is the appropriate person to make the ruling on the motion. We don't believe that Judge Foster, one, has the authority to do it, and then two, would be in the best position to do it.
He wants her to rule on. I don't blame him. I'll tell you why. Because he can tell that Judge Kite is like, well, I guess like any rational person, right? It's like the defense is like making a lot of great points and they have salient arguments and they're following through with their word and they're not fucking around and they're providing the good case. And then you've got the prosecution, right? That's, you know, I mean, as we saw, right? With the Taint team was a great example. Taint agent. And so no wonder they want her to rule on this because they know she will make the best decision for them and for their clients, right? But in my view, also in this case, with what we've got going on right now, that would be the fair decision and the right decision. And potentially someone who's not as familiar with what's going on might not understand the complexity of this, right? And they might not make the proper ruling.
Is there anything you want to add, Mr. Nazario?
I'm not going to respond to the entire argument that was made.
Oh, for Pete's sake. Wow, rude.
Other than to say that's exactly why the court would be in an impossible position to rule, is because of everything you just said. And so I thank him for supporting our argument, our position that the court has to have the knowledge of what the defense is claiming was misconduct before making a decision that the remedies that they asked for. We have lots of responses to the arguments.
Judge, I don't think I said anything about necessarily the content of any of these communications being, at least at this time, being known to the court in order for the court to rule. We're focused more on the state's actions than the content of any specific communication. And I don't believe the case law supports it. The court needs that information to find substantial misconduct.
Do you have an idea of what Judge Foster needs to review related to the Gardner case?
I believe he has hope. According to the defense, we don't have the information.
No, I mean, so the search warrant that was served on the Google, what's it called?
They're served on Google Inc.
Google Inc. and then the iCloud. Does Judge Foster have that from the state's perspective?
He has the defense submitted to them as potential attorney-client privilege. That's what they represent.
And you're saying we haven't submitted everything?
I'm saying there are still things that we were finding as of a week ago. But again, we've not gone back to Judge Foster and submitted them because they are not the center of our case. Just like Mr. Dreiser was talking about those 60-something emails, you know, we don't know that those are necessary, as our position is simply that they went around the court ratified agreement to use a taint team and seized information and data that they knew had attorney-client privileged communications on it. And once they got it, they didn't give it to the taint agent. And there are issues with the taint team that I'm not going to get into. But they didn't give it to the taint agent, that they just started reviewing it because they felt they could. And that is wrong. It was in violation of the court-ordered agreement. The prosecutor's office knew that they were getting that data. And when they went to the second, you know, again, I don't want to argue Your Honor, I just laid out our motion, but we are focused more on the process that the state used and what in their conduct than we are in any specific communication.
Yeah, I see.
And unlike Mr. Fernandez, the state has not told us that they have anything that they intend to use against Ms. Gardner that they should not have gotten their hands on. You know, I think in Mr. Fernandez's case, I think the fact that they were going to use it as evidence is de facto prejudice because they've admitted that it's prejudice. They don't have any.
Interesting. So there, he's actually commenting on that, which is so that's really interesting. It's almost like arguing also for Mario's defense, like because what he's saying right here is it's de facto. Interesting. De facto prejudice. Wow.
Thing in our case that they've said they've gotten their hands on the so we're in a little bit different posture.
It's so funny because I called this, right? I mean, at the beginning of last night, before we watched the hearing, I commented on when you were going through the documents, I was commenting on how, you know, sometimes there could be things that could be different between the both of them because they're going to have their own different discovery and they're going to have their own different, you know, set of facts and blah, blah. And it's just really funny because that's just becoming more and more apparent that they have some overlap in the issues, but they also have, what he's saying is almost the way I read this, right, is like we have equally as important issues. And that Mario's biggest thing that is distinct, you know, makes it distinctive is that they've already said that they intend to use some of this as evidence. And he's saying with us, they haven't said they haven't specified what they intend to use as evidence or not. But we have all this other stuff with the iCloud, and then also with ASA Stifler seeing it and all that stuff too that happened recently after the last hearing. So they each have their own separate things as well.
Right, I'm going to wrap this up and I'm going to take it under advisement.
Yeah, I don't blame her. This is complicated.
He was going to let us know.
I thought reading tea leaves, it was an April 8th date, and I think he's probably using that as a barometer.
I get that just so these cases don't fall off. I'll just keep it on the April 8th date and I'll issue an order on the state's motion to clarify. Okay.
Yes, Your Honor.
Thank you all very much.
Okay, so what I can say too is like they are really pushing their this is crazy. Like you don't usually see this because like when I was going through and pulling all the videos for the playlist, actually let me pull that up, the next one up. That they have these hearings back to back to back. Like for example, the next two are 3 days apart in terms of what's not in camera. So there's like April 8th and then April 11th. But what's crazy is that that's already crazy to have two hearings that close together. But there's also a hearing on April 10th. April 9th, I think. But it's in camera. So like, even though that's like so crazy to have hearings April 8th and April 11th, that's not even all. They had an April 9th that was in camera. They are really trying to get this figured out. And I understand. It's just amazing that because sometimes, you know, this courts, they can't always do that, right? I mean, it's not easy to have that type of, you know, schedule. But they're really working hard. I mean, this is unusual. So, you know, what we usually see is like they have their hearing on whatever, and here's whatever the issues are. And then it's like the next thing that they schedule is going to be at a minimum a month out, right? Or if not much longer, but usually it's not less than a month. And then here we're like day by day, back to back almost, right? It's just really crazy that they're able to do that. So let me pull up the next one. Hold on. Just a second. Okay, so this is I'm going to pull up here in just a second. So again, this is from April 8th. So let me, okay, hold on just a second. Okay. Okay, so now let's see here. Oh, wow. So they got started pretty quick on this one. All right. Oh, this one does not have, hold on. This one does not have, I don't know if it's necessary. I don't even know if anyone's cares. This one does not have subtitles available, but I don't know if that really matters. I mean, they're usually incorrect, but I'm just so used to whenever it's on YouTube, I'm so used to just pulling those up because I got used to doing that for Karen Reed. But yeah, anyway, they're not available. So. So let me fix my banner. Go in prison garb.
And Your Honor, I'll leave Ms. Gardner's appearance this morning.
All right, thank you. All right, I'm assuming that you've both got the order that I entered. Okay, so since I'm taking the review back, what I'd like to know is, I'm not sure what got provided to Judge Foster on behalf of the defense, and I'm going to address Fernandez separately because I believe that they're separate issues related to both. Okay,
so, I agree. Good.
Do you need to get materials from Judge Foster, or do you want to provide me something different?
I am perfectly okay with everything we gave Judge Foster. You reviewed.
Okay.
With the understanding, I think everyone that in no way are we waiving the attorney-client privilege by allowing you to review it. You know, there could be some argument made that, well, if they said they're perfectly fine with you reviewing it, then it's with the understanding that we're making some exception for court review, right? It was more clear with Judge Foster, but having said that, yes, everything that Judge Foster has is unredacted. The state has it in a redacted format, and I believe it was filed in a redacted format. I'll double check that. It was supposed to be filed. If it hasn't been, we'll make sure that gets done so that there's some record as to like dates and times. So whatever your ruling is would be reflected on a court docket. Does that make sense?
Yes.
I like Mr. Dreiser. I think he does a good job too.
So there are two documents that the state has that are both titled confidential communication, correct?
Confidential communication, confidential timeline.
Okay.
And they're attached to the emails back and forth between my client and our office.
And there are 66 emails, correct?
Well, let me kind of just go a little slower.
Those are separate.
And then there are emails that discuss the attachments, which will be enlightening for the court to understand how they came to be and why they came to be and what they serve some purpose for. They're attached to the, where you can see the attachments, and then of course we attach the attachments in a physical copy. That's one portion. That's what we initially delivered to Judge Foster. Then there is 60 some odd miscellaneous emails, which I believe all of them are titled in the subject line, confidential communication.
Okay.
And there are a variety of subjects over many months, if not over a year period of time. And the only, and I'll say that, and then whether or not, and our position is, and I think the state would at least acknowledge, they had access to all of those, they just maintain that they've never seen them.
Okay.
Docket line 163, Your Honor.
Thank you.
Thank you, sir.
Do you think that there is any need for me to look at these? I will say category B, these 60 miscellaneous emails, if the state of Florida is saying that they did not, well, they had access to it on you. Do you think there's a need for me to look at those?
I think, yes, to understand the case law as to whether or not you may determine to disqualify the office versus individual lawyers within the office. I think you have to understand that those emails all were able to be accessed via.
I see what you're saying. Yeah, yeah.
Butler and various other
that makes
law
sense.
enforcement.
Yeah. And remember, the law enforcement still counts as part of the state. No, I agree. And this is what makes this case. You see, for me, again, I was not planning on covering this because, again, it's just I was like, okay, you know, it is a lot. It is kind of similar to the Adelsons. You know, I don't know. You can't cover. You can't even follow them all, right? There's so many cases. There's so many trials. Can't do it all. And so usually it's like if you're going to narrow it down, even just for what you're watching or covering, if you're me or just one person, you know, it's like you have to sort of there has to be something distinctive about it or something that you find particularly interesting. And what I will say is that, like, while what made me want to cover this was learning Jose Baez was her attorney, which I learned that at the time when when this first started. But you know what I hadn't done at the time? I hadn't ever watched any of the Casey Anthony trials. So I just was like, oh, that's interesting. But see, now he's like my favorite defense attorney. And I'd forgotten that he was her attorney until Flash Fan, thank you, you reminded me. But you know what's even better? He's right. These are all of the defense attorneys are great. They're all great. And you know what? One thing that makes us so distinctive in terms of really worth watching and worth following, when there's really good lawyering, that is always makes something so much better. Like, you know what I mean? Because regardless of whatever happens with the case, you know, the defendants, whatever, like the really good lawyering is always worth watching. I love seeing this. And yeah, so yeah, I'm glad I picked it up too. Thank you. Yeah, all of the defense attorneys have done a phenomenal job. It's really a treat, and like I feel like spoiled or something. It's like a luxury, you know.
You have to at least look at them to understand that. Whether you have to read them, like the body of them, I don't know that you do, right? You just have to
Beautiful
understand that they
courtroom
exist
too,
and
by the way.
understand-
Like, can I just take a second to say, look at this courtroom. This has a very similar look to it as the Orange County. It doesn't look like this room is, you know, the other one has like that vaulted jury box, you know, it's like a auditorium or like a opera hall or something, concert hall. But like this could be a smaller room, and they could have a room like that. I don't know. But even still, even though it's not like the vaulted ceiling and like the different levels, the style is very similar. And also it's very modern and very new looking. But like the colors, it's like the cooler colors, you know, like in terms of the shade of white and then the shade of brown, and then the type of engraving, like it just has like a cohesive look to it, which I really like. I will say that like the courtroom where, which courthouse is it? Where the one in where they were having the Adelsons, I can't remember the county for that. For whatever reason, it's escaping me right now. But that courthouse is very different from these ones. And that courtroom anyway. But like I like how this one or again, it's a similar aesthetic. That's the word I'm looking at. It's similar aesthetic. And I really like the aesthetic. And I like the cooler lighting versus the really super warm, you know. I really like it.
that if the evidence were to show that they did have access to them, I think you are going to have to consider that in your evaluation.
Right. And this was all provided to Judge Foster.
Yes, ma'am.
Yeah, I mean, this is a large courtroom, but compared to the courtroom, Flash Fan, have you seen the picture? Because I know I've shown it before, but maybe not. I don't know if you've seen it. The picture of like where Casey Anthony is, you know, for Orange County, of that courtroom from the opposite set, like view. Because you may not realize what that courtroom is really unique. If you haven't seen that picture, let me know and I'll pull that up. But like this is large, but compared to that, this is small. That's what's so funny.
And there's nothing that needs to be supplemented from the defense perspective.
No, ma'am.
All right. This is state approved.
Yes, other than the one document entitled confidential conversation. I mean, I was entitled confidential timeline. Other than that, yes.
Okay. All right, let me address Gardner now.
No, Sarah Boone. No. Sarah Boone, it's not the same. She was in the smaller one. Nope. It's room 23. Courtroom 23 is the big room where Casey Anthony. Sarah Boone, some of the jury selection or the voir dire was done in that room, and they were initially gonna like use that room, I think, They never actually did. So you guys, anyone that followed Sarah Boone, you never saw cameras with that room. You never saw anything happen in that room. They used this. No, I'll show you. Hold on. This is worth seeing because it's really something spectacular. It's really, really, really incredible, actually. Let me pull this up real quick. See, because I haven't been doing this intro video, and that's where I have it. I stopped doing, I forgot about it, actually. That's why you didn't see it. So let me find it on here. Okay, hold on. Okay. Well, first of all, let's see the outside. How do I have this in order? Okay, well, anyway, we'll see. So there's the IKEA. Okay, it's coming right up here in a second. So this is like the intro video I used to play at the beginning, but I kind of forgot to do it. So, okay, so this is the courtroom if you're in the balcony. And I'm sure this looks familiar. And if you're like, what's the balcony? Don't worry, you'll see it in a second. So if you look, so this is the courtroom again. This is where Casey Anthony. And so to the left, look at that jury box. Look at how many seats. And those are all like, this is the room. So, but look at how high the ceilings are. Okay. Now here's the other view. This is what's wild. Hold on. This is courtroom 23. I should change here in a second. There. Look at that. Look at that. So that is what I'm talking about. So that's the view from the opposite side. Where you're facing. So they have that balcony. Isn't that insane? So that's what I'm talking about. Like that, I don't know how many other courtrooms are like that. I've never seen one. There's the outside. That's the outside of it. State of the art. I mean, it looks, look, there's another picture of the house. I mean, you would never, like, the Guilford County Courthouse looks like a jail. Like, this is incredible. And I mean, the aesthetics are so on point. And let me go back. Look at the whole thing is windows. Incredible. And all that natural light. I mean, it's really spectacular. That's why I wanted to show it, because for anyone who hasn't seen it, like, that's really something to appreciate. Anyone that watches trials knows, like, this is really something else. And actually, I knew someone who was there for Sarah Boone and was there live, like contending, and they were there including for voir dire jury selection. And they were like saying like the building is really immaculate. And they were just talking about how nice it was. It was like a fancy hotel or something, you know? But like usually some courthouses, I mean, can be like here at least grungy, awful, like not, I mean, just it's crazy to see the difference, you know? But yeah. Hold on, let me see. Oh, StreamYard is okay because I pulled up a video file. It doesn't like it. Let me get rid of that. Okay, so now, yeah, I know, right? It looks like a monument. Yeah, totally, right? It's pretty insane. Yeah, but I mean, that balcony thing, it's like a concert hall. I mean, that's really what, and the way it's like vaulted, like floating, like that balcony, right? It's like not separate. It's not like a balcony standard you'd have an account. It's vaulted, like they're suspended in the air. It's so modern and it's just so. So Duval from the outside. I haven't made an intro video for this, but if you look at the thumbnail, any of the thumbnails, I guess I could pull one up. Let me see. Hold on. Okay, let me do this. Hold on, I have to just get this so I can share it. Okay, here we go. So, can I zoom in? There we go. That's the outside. So again, very similar aesthetic, right? You see what I mean? Even though it's not tall, it's very similar. Like, you remember how the Orange County was like really tall, but then the front of it looked like a normal, like, what do you call it? I don't know what the name of the style is, but like basically what I'm saying is like the part behind the Squangwen, right? Like this looks very similar, with if you were to take the tall part and stick it behind this, except that this is also a little bit wider. But like the aesthetic, like in terms of the front part with the like the roofs being in a triangle, I don't know what to call it. And then look at the windows, is the aesthetic is like very much the same. You see what I mean? So it's not tall, but it's wider, I think. Now it makes sense because, I mean, Orange County serves a huge population of people, right? I mean, like how many trials are out of Orange County? Like, I mean, it's insane. And it's a very large jurisdiction, as I've learned. And there's just a lot of, you know, and then Jacksonville, Duval is just a little bit smaller, right? I mean, so, but again, this is much wider. And I think it's even wider. Like it goes wider than what you can even see in the picture, because the picture it's like zoomed in. So it's quite wide, but they went wide instead of tall. But like the aesthetic, look at all the windows. It's very similar. Oh, this isn't the one with Judge Kite on it. Anyway, it doesn't matter. The building's the same. So the newest thumbnail has Judge Kite. So, but I mean, let me see if I can pull up a picture of the Guilford County Courthouse just for comparison's sake. Let me see here, because prepare to be underwhelmed, like in a major way. So I'm just so silly. Y'all will lose your minds on this one. Gotta find one that does it justice. We got to get one with is there a picture with the parking lot? Because the parking lot is atrocious. Oh, this is a good picture right here. This is a good one. Oh, there was a fire. Well, it doesn't look any different now. Oh my God. Okay. Can I make this big? Let me see if I can make this big. Hold on. Oh my God. Now it's making me disable my ad blocker. Oh my God. How annoying. Hold on. Shouldn't be this difficult. Hold on. Ugh. I don't want to remove my ad blocker. Oh, this is stupid. Hold on. Let me see. Why? Disable my ad blocker. Oh, for Pete's sake. Okay. Let me see here. Stupid. Well, we'll just do it this way then. How about that? Because, you know, all right, let me do this. So let me share this. So the picture I was trying to do is this one, because this is really what it looks like when you enter it. Like this part that looks fancier, I don't even know where that is, because I had to go for something really stupid. Like when I moved, I don't know, I had to go for something stupid. It was just like to change of address or something stupid. But anyway, and they make you go in, and this is what you see when you go as a person, and it looks like this. It looks like a jail. And you have to, the parking is a mess. And then you have to you can't even enter the building without taking all of your belongings and putting them in lockers that are outside. It's like, what? Like you can't, it's really, I don't even know how it's legal, to be honest. I was like, it feels like you're going, if you know what it is, it feels like you're being booked into custody, because they're like, okay, here you go. And you have to pay for the freaking locker. So that was the other thing. It's like you go and you're like, what? And then it's like, it has to be quarters. And it's like, how do you, so you have to go get quarters so you can go, and then you can pay to get the stupid orange key. Of course it's orange, right? So that you can put your stuff outside in a locker, and you have to memorize the number for it. And there's a bazillion of them. And it's crazy. It's crazy. Anyway. But yeah, so that's the Guilford County Courthouse. I mean, that's what I'm dealing with where I live if I ever go there. But, you know, it's just an eyesore. It's really on. Oh, yeah, this also. Yeah, that part. Anyway, so there you go. Yeah, this is the entrance. That picture right there, that is literally the entrance from the parking lot. That's what that's the grand entrance. Compare that to the other courthouses that we just looked at. That's it. Look at that. And by the way, it's like really confusing and like, oh my God, it is what it is. Okay, let me go back to the hearing though. So let's see here. Yeah. Oh, I was sharing my window, so I just stopped sharing. All right, here we go. Okay, and we're back to where we were. Yeah, I'm jealous of all this.
Mr. Freddie, I believe that my understanding of the last hearing is that you do not want me to reach the substance.
It does seem like it stretches.
And my understanding from your pleadings is that there were, I guess, these devices where search warrants were served, and then it was divided out amongst detectives to review the search warrant results. And you were still, I guess, gathering or figuring out what was actually
the search warrant results.
Google, whatever that was in the iCloud. Is that correct?
Yes, Your Honor. So our motion rests more on the substantial misconduct prong as opposed to the other prong with.
This is what they said last time.
Prejudice, the misconduct prong does not. But we do not have any objection to the court reviewing what we provided Judge Foster to date. And
what did you provide?
Yes, Your Honor. We provided several recordings that were, one was a phone call, there were a couple of voicemails, and then some emails and text messages. It was not substantial, Judge, but we do believe it's important that the court review those just to be able to make a conclusion that there were, in fact, attorney-client communications on these devices.
Yeah, I know. I do love this courtroom. Yeah, I bet it will be. I think it's an appropriate size.
Is there anything in addition to the state wants me to consider related to
The other thing that you can already tell is like they've got the cameras worked out, they've got the sound worked out. There's no issues. It's all good, and I do love this. I love the lighting in this courtroom too. Not her again. Why, ma'am? Ma'am. Remember, this is about that whole issue of that they got subsequent search warrant. Dude, I can't.
And we intend to provide that and other documents to the court. I never said the state didn't review everything. They did, in fact. We know that the state did, in fact, or prosecution did, in fact, review communications between the attorney-client that were covered by the attorney-client privilege because the agent or analyst reviewing them reached out to Ms. Stifler saying, hey, I think I'm reviewing attorney-client communications. So we know that the state, their whole team did, in fact, review attorney-client communications. So it's not what we're saying. We provided what we have. We don't know what exactly was reviewed by the analyst.
Why not?
Because we did not ask that specifically. We did not want to air it in the deposition because, you know, that was our opportunity to speak to the analyst. And we confirmed that she did, in fact, review materials between Ms. Gardner and her attorneys. We just don't know exactly what those details.
On that note, Your Honor, we did not discuss this. I think now's the right time. The state and I and Mr. Carodi, on behalf of Ms. Gardner, agreed that Judge Foster could read the depositions that we took and we provided him transcripts. And I believe, unless the state has there's down in your head, we all maintain that I request that you read those.
Okay. How many did you provide?
Two. Agent Nazario from
There's the agent.
And Laura Butler, an analyst.
Oh yeah. I mean,
Lindsay Butler, an analyst.
it could be a lot worse. I mean, we can hear it. That's
would agree
saying
with
a
that,
lot
Your
when it comes to this stuff.
And we will supplement it and provide you additional documents, the warrants.
And it'll probably improve as it gets closer to trial. But I mean, at least I can hear it, you know.
I provide it this week, Your Honor, by Wednesday, with copies to the state.
Audible.
I don't know if this is necessary. At the deposition, Ms. Butler, she testified, everyone was present, that she began reviewing an iCloud return. She observed a message.
Was this the one that didn't have?
She ordered the state. My response was, shut it down, send it out, stop reviewing. So my view of her depo transcript.
I am shocked that she's talking at all. Why are you here?
She saw one communication.
Go away.
Freddie did not ask what that communication was. if they need to know what it is, certainly Ms. Butler, I can arrange for her to speak to them outside the presence of the state or in camera with the court to let them know the one message that she did view or see or realize was on that. But we haven't reviewed anything. She didn't tell me the content of the message or provide it to me, so I have no idea what it is. But I don't know because she's now out of state. If they're requesting her to give any kind of testimony regarding this issue in camera or otherwise, I can make arrangements for that as well.
Just so that we're clear that there is no guessing, why don't we have that done this week?
Yes, ma'am.
Yes, Your Honor.
Okay.
And just so I'm clear, the idea would be for
In camera.
for you to talk to her in camera.
No.
Okay. For just the defense to interview her with.
I'm gonna make.
I mean, here's the thing. So I don't know how this Stifler, I mean, obviously there's misconduct going on. The thing is that with Casey Anthony, because the question here is being who I hate worse, her, Miss Greenberg. The thing is with Casey Anthony, none of the pretrial hearings are available. So I don't know if Miss Burdick, did some sort of fuckery that's akin to this. I would hope not, and I would doubt it because I feel like it's pretty rare. And so likewise, I also can't really compare Miss Stickler to Miss Burdick because I haven't heard her argue at trial, and I don't think I will because I can't imagine she makes it that work. I'm sure she's gonna get, I feel like she has to get kicked off, right? So if I go off of just what I've seen of both of them, which aren't really comparable, I will just say I really hate Miss Burdick. I mean, the reasons I hate her, it's like whether there was fuckery or not, I can't stand, dude, you guys know, I can't stand, I hate the way she talks. I hate everything about her, man. She gets the decade wrong and it just is so annoying. And she just says stuff that's like, what the heck? Every time I'm watching, she's like, questioning a witness. I'm like, oh, anyway. Although I will say that on the motion for a directed verdict, I hate her for a different set of reasons. But she might always be my least favorite prosecutor. I don't know. It's gonna be tough because even though it's like there's a lot of fuckery that's like awful for her, like the way she's like nails on a chalkboard for me, which in some ways is just sticks with you more like I'm allergic to it type of thing. Anyway, that's my thoughts.
A record, I'm gonna seal it. You can ask her the questions that you need to.
Understood, on the record in front of Your Honor.
Correct.
Understood.
And then we'll do it here in court. I'll close the proceedings in camera. You can make it record. I'll seal the transcript. Okay.
Yes, Your Honor.
And I will not be present for that.
Yes, that's correct.
And I know this is so confusing because you haven't seen this stuff yet. That whole dialogue between the state and Mr. Brody and what Lindsay Butler saw. Or didn't
I would
see
say I almost hate her more than Molly, to be honest.
issues
Oh my God,
that she did see.
I said that before I saw the question. That's really funny. What about Lolly? Yeah, I mean, here's the thing. Maybe it's just because I haven't heard Lolly talk in a while, and maybe I would not be saying this if I'd heard him talk recently, because in these recent hearings, he just sits there like a toad on a log and doesn't say anything. So maybe that's why I've just forgotten how much his voice is awful, and hearing him drone on and on and on is awful. But again, this isn't going on fuckery. This is going on like the droning on and on, like the voice and just like the little things but they can really add up and really bother you to be annoying. Like Elaine would also be in that category. Okay. Elaine from Det v. Heard, because I know Flashbane has not watched that trial. Elaine from Det v. Heard would also be in this category where it's just like, ugh, I don't know. Right now, again, I'm like, and maybe it's because I'm watching it right now. Right now, I'm like, I think Miss Greenberg might even surpass Lolly for me for the annoyingness. But then I'm like, maybe it's just because it's been a while, But right now, that's how I feel about her, is like she takes the prize for the one the nails on the chalkboard award, if you will. I mean, yeah, I really don't like her.
I'm very,
and I don't think she's competent at all either.
His case and the issues presented are a similar issue in my mind, because the state as saying that they have access to it. They said, that was my understanding, that you all think was evidence, not attorney-client privilege. So that's, to me, a simpler issue to resolve. At this point, I don't want any guessing. I want to be able to, for you to be able to identify the information accurately so that you can make whatever arguments you need to, and then I can review whatever you believe would be necessary for me to make a decision.
Yes, sir.
Okay. When do you think you can have contact with this witness?
I can call her in court. She is out of state, so she either has to travel or through by Zoom.
Do you have any problem with Zoom testimony?
No, Your Honor, not for
That would make
purposes
it a lot easier
Not for purposes of this issue.
So as it pertains to the question about the new Karen Reed, the best way to get my opinion on that would be to watch my coverage of those hearings, because it would just be way more relevant, because I give my thoughts on him as he's talking and as he's making, you know what I mean? Like it's hard to kind of make those talk about that out of context. But yeah, I have a lot of thoughts about him, and I, you know, so far there's been 2 hearings, and so I would say, you know, if you were curious about my thoughts, you know, you could watch those, and that would also put it into context. Because sometimes it's like I would say, I might think one thing, but then it might change depending on what happens. And I will say, just generally speaking, I think I noticed a big change from the first hearing to the second hearing. There was a big change in my opinion. I actually I thought to myself, did he get the Canton brainworm? Like in the duration, they had the first hearing where he was appearing, and then the next one, which was the more recent one. And I was like, what happened to him in between? Like, what happened in that 1 month time period? Something happened to him. It was really crazy. There was a big difference. And I think I talk about why maybe that is in that second hearing. I'm pretty sure I talked about it because it was pretty distinctive.
So don't forget, we're still going to have, you still have to go through the whole 2E process. The AUSA is going to have to
2E process.
Specifically say what you're asking her to do. The AUSA.
Is that what she is, a special agent?
She's an analyst at ATX. Yes, she does an interview letter. It was not improper.
If anyone doesn't know what 2E process is, let me know.
I'm not suggesting it's a problem. It's just a process. It takes process. There's a
I
difference.
understand how 2E works. If Mr. Curry can give me a letter today or tomorrow, I think we should be able to.
Your Honor, I can get her a letter before close of business.
So it's something that needs to be arranged next week.
Let me speak to her today, and I can let the parties know by email if we'll get it done this week.
Where is she out of state?
Washington, D.C.
Do you want to hold off on the materials? I'm gonna push forward before it does, okay? Since it seems like I have everything. And so, based on, I think I'm gonna separate the 2. Y'all are gonna be appearing for these hearings together, unless, you know, the attorneys want to come, but I'm not gonna have.
Well,
present for Fernanda.
Mr. Baez, even though we haven't seen him yet.
The attorney-client privilege separate and even.
I mean, we've heard the most from Mr. and well, rightfully so, right? Because again, who's had the most time in the court? Who's got the most time on the case? You know, Mr. Dreiser has that. It makes sense that he's done a lot more talking than anybody so far. Jose Baez is my favorite defense. It's gonna be tough for me to ever come across a defense attorney I like more than him. Honestly, I really like there's a lot of great defense attorneys that he's got tough competition. So I don't say that lightly. But he takes the cake for me. But in terms of who we've really heard from so far, Dreiser. I mean, I don't even know. I guess the other one is Mr. Cox, who's been arguing for Shanna, but we haven't heard him that much. But I do think the motion was really strong. But Mr. Dreiser has been spent a lot. We've heard him a lot more. But I mean, again, it's like because they're all great, it might be whoever talks more seems to be stronger that day. So I don't know. But yeah, Dreiser's awesome too.
Gardner's attorney should not have any access to that information. So I'm going to separate these hearings.
Judge, I guess the only exception would be if we are going to take the testimony of Agent Nazario and Lindsay Butler on the record. I know we're going to provide your honor with the depositions, but that may be something that we want to do together.
Why?
Why would we want to do it together?
Right.
So that we don't
Did she have some involvement? Well, I thought you asked the questions you had during deposition.
Yeah. I think I flushed out my issue without ever addressing the specifics. I think
If you want to ask questions.
I don't think I need to. I'm not sure that I need to. I think the transcript you have answers the questions you'll need.
Yes, Your Honor. Okay, if the courts can accept the transcripts and use those as substantive evidence for the motions, then I don't believe we'll need to recall these witnesses in person.
Except for
the ex parte in camera.
Okay. You don't have any problem with that?
No.
Are you going to agree?
Yes, Your Honor.
Okay. How long do you all think the hearings should take? Let's separate out for Mr. Fernandez's case.
I'm sorry.
I was asking how long do you think the hearing would take? I'm gonna.
Oh, okay.
Our last pretrial on this issue was 40 minutes. So.
Oh, Crody, okay.
I want to say argument. We'll have seen everything. 2 to 3 hours, and maybe.
I think they're talking about for the evidentiary hearing, because they've gotten one more short hearing before they get to that one.
Way long, but these are complicated issues.
Yeah, they're talking about the evidentiary hearing because I think they split it into 2 parts actually.
April 6th, I'm sorry, April 26th.
Yep.
for
Yep.
Hernandez,
Yep.
And I'll give y'all the whole morning.
That's the evidentiary hearing. Cool.
Yeah.
Can you guys see this? What is this? Hold on. I wish I could zoom in. Look, can you see my mouse? What is this? What the heck are we looking at there? It looks kind of like an older, like Chinese dude or like Japanese. Like it looks like, it's hard to explain. It's supposed to be like an ancient samurai or like, well, I don't know. It's very, I don't know if you guys can see that. I don't know what that is, but it's not expected to, it's not something you would expect to see. You know, you would expect to see maybe a picture of like Thomas Jefferson or like Benjamin Franklin or like, I don't know, some sort of founding father, or I don't know. It's funny. I don't know. I'm so curious. I wonder if it'll be there at every one of these. Oh, well, no. Well, having said that, Jose Baez is death penalty certified. I mean, as we know. Yeah. Baez. I mean, you could have more than one, but yeah.
I can do the 19th, but it would have to be in the afternoon. I feel that my morning DOP hearing is in the 30th.
Although when you're hiring private, I should also say, when you're hiring private counsel, that's not a requirement. It's recommended, but it's not a requirement. Chad Daybell, for example, waived that when he hired John Pryor, who had actually never tried a death penalty case in his life. And he said, I still want him to do it. But when you're having court-appointed counsel, they do have to be death penalty qualified. But in the case of here, right, you know, these are private attorneys. But in Casey's case, remember, initially it was supposed to be private, but then she was declared indigent. But again, Mr. Baez would be death penalty qualified because he was her attorney, and it was he ended because of the fact it was court appointed. Like in that situation where like she was declared indigent like at the last minute, like they would have to that could have been a problem. Like they would have had to, if he wasn't death penalty qualified, they would have had to probably continue the trial and then find someone else who could assist on the team and then get them up to speed, and that would have been a whole problem.
I'm free. I have a mediation that was set for that entire day. If I had to move it, I guess I could.
Oh, interesting.
Choice.
No. Okay, so at this point, it's the 19th in the afternoon. I have a DOP hearing on May 3rd, but I'll move that, and I can give you all the.
What do you mean he wasn't during Shanna's first? They're not. I mean, the death penalty arguments didn't start being filed until November of this year. So I'm not quite sure what you mean. But it could be that he was brought on later in the game, you know, because again, she initially had that Mr. Cox. I don't know. Maybe he was like added to the team. I don't know, after the other guys. Because remember, she had hired that firm for the thing about the kids being in the media. And then I wonder if that's how she ended up with Mr. Crody, which would make sense, right? And then to keep them in the same firm, because we'll see people do that. And then I wonder if they brought Mr. Baez on after. So, but yeah, the death penalty motions didn't start to be filed until, at least for Shanna, until November of this year. So just last month.
May 3rd would be great for the defense.
May 3rd.
Oh, I know what that means. I can tell you exactly what that means. Interesting. Okay. I see what you mean. So what that means is that, okay, that's your CLE. So your continuing legal education. So you have to, this is required for attorneys, and they all complain about it. Like it's like your ongoing education where you have, there's certain ones that you have to do, but then there's other ones you can do that are extra. And like, there's all these jokes about like, oh, I'm doing my CLEs, and then I'm like also listening to this live stream, or I'm doing whatever. Like there's like, people joke about it, right? It's supposed to be like a big pain, essentially, is the vibe I get from people. But it's your continuing legal education, kind of like how other professions, they have like ongoing training they have to do. And so this is what that is, right? So it's like, I would imagine that there's certain things that are yearly, but then there's other things that are maybe like bi-yearly. And so, and they're time consuming from what I understand, they're time consuming, they're annoying. And oftentimes you don't actually learn anything. So it feels pointless. And they also cost a lot of money. But I think that for, most attorneys, the money is probably not the issue. It's probably more like it's a lot of time and it's really boring and you don't learn anything. Like I've heard everybody complain about it, even like EDB, who doesn't really complain about stuff. Like she complains about it, like where it's like so useless. They're not actually teaching you new things. Like actually one of the things she says is like they should be doing CLE, but it should be on like how to use technology, because as we know, everyone is like dinosaurs in the courtroom and they don't know how to do anything. And they're like even trying to figure out basic stuff. And it's like, that would be something for CLE, right? And instead it's like stuff that is not really relevant and all that. So that's CLEs. So essentially what that means is it doesn't mean that he's less qualified or less anything, right? What it means is that he hasn't done the CLEs because it wasn't necessary. Like, and that makes sense where it's like, you wouldn't be allowed to, I see what you're saying there. So I would imagine that he gets that caught up and then jumps in, right? Because I think he did write those motions. I'm trying to remember that were filed in November, but that makes sense. Like if you're not caught up on the CLEs, then now again here because because of the fact that he's a private attorney, right? He's not court appointed. Technically, it shouldn't really matter. But again, I guess Shanna doesn't want to waive that. Wait, no, again, sorry, that's only if they're court appointed. So I don't know. I mean, it could be different in Florida. Maybe that's the distinction. Let me look it up. It could be different between Florida and Idaho. I'll keep playing the hearing and I'll look it up because it could be that in Florida they require it no matter what. So let me look it up.
Well, you all have the court stuff. All right, so case number 4. The next court date will be May 3rd, 9 a.m. hearing on motion. And if you would put in the notes, Mr. Hathaway, 4 hours.
Yes, ma'am. And Your Honor,
I'm sorry, I broke that 3 hours.
if for whatever reason, I can't imagine this is the case, but for whatever reason, Judge Foster marked up and you want clean copies, whatever, just have your JA reach out to us and we can get it to you right away.
Okay, thank you very much.
We also, both the state and the defense, the only thing that wasn't mentioned is there's some case law that was provided, and please review that as well for both.
Okay.
And with that, may we be excused?
Yes, thank you very much. All right, Mr. Brady.
Judge, we would ask for that 419 afternoon.
Your Honor, I want to correct myself. In regards to Ms. Gardner's motion, I do believe the state would probably seek to elicit testimony either from Agent Nazario or myself to clarify some of the issues regarding the access, if that's what their substantial misconduct allegation rests on. I think we would need to elicit further testimony on that aspect. Now we have their motion for the position. I don't anticipate it'll be lengthy, but I did want to put this on notice.
Okay. I'm gonna pass this case later on the same week. I want an answer on the 2-week issue, how long that will take in order for this agent to appear. So I'm thinking maybe Wednesday, if you could have the 2-week information to the state.
Yes, Judge.
All right. And then I'll schedule the hearing after I know. So in my mind, this is going to be a scheduled course. We're going to get an answer on 2-week this week. Then we will schedule the in-camera hearing. All right, maybe a portion. I have the state here just in case something comes up or there is some kind of issue. I'll ask that you step outside and take the testimony of the agent, and then I will give you a pass date for the actual hearing. Okay, on the defense motion.
Judge, so all the attorneys for Ms. Gardner are available on 419. We also have the outstanding bond motion. So I do have concerns that if we keep pushing this and pushing this and pushing this, I understand that the court is doing, what I agree with as far as the order of events. I'm just wondering if we can compress them and maybe hold the 19th as a placeholder.
I'm fine.
Okay.
I'm fine doing the 19th as like a stop time, but I need to have the information. So And I'm not gonna go based on a guess by the defense, like, these are serious allegations.
Yes, Judge.
So I need you to identify, what you want me to review, okay? So we can do 1 to 5 on the 19th, if you would block that time, I'll block it.
Thank you, Your Honor.
So, Shanna Gardner's case number 6, we'll set the following dates. April 10, 9 a.m., that would be status hearing.
Okay, so they are.
I have time, I should have.
Okay, so I'm just pausing real quick. Yeah, so in Florida, here's the deal. So in Florida, it says so for capital cases, so death penalty case, right? There's a long list of things that you have to have, and this is as per the Florida rules of criminal procedure and the Florida bar. Okay, and there's a long list of things, and all of these things I'm sure that Jose Baez has, but this is the last one. It's number 7. Have attended within the last 2 years a continuing legal education program, that's the CLE, of at least 12 hours duration. Remember, I said it was time consuming, devoted specifically to the defense of capital cases. Now, here's the thing. He knows how to do it, right? You can see why. And again, they're considered to be really boring, really dry, redundant, and all this. And so 12 hours. So that's the thing that he was missing, was the CLE for this. And you can see why it's not something you would do until it's required, right? So what I'm wondering, though, is if after he was brought on for this case, and, if at some point he was like, I'll have this done so that I can file the death penalty motions or whatever. And that's that's to be considered lead trial counsel, by the way. And it does not specify if it's court appointed or private. It just says lead trial counsel. Assignments should be given to attorneys who meet these certain criteria. And again, he meets all that criteria. That's the CLE. So it might be that, it looks like she's got like at least 2 attorneys who are qualified and meet all the criteria, and either one could serve as lead counsel. And it doesn't really matter either, right? Because that's just a title. Like sometimes the lead, this is true for both the prosecution and the defense in cases where, I think I talked about this recently, actually, where somebody who's the lead doesn't actually do the most stuff sometimes. It just depends. Like they might actually be count like the lead, like on paper, but like they're not, you don't see them as much. So, oh, really? Interesting. That's interesting to know. Okay. See, again, because that, like, when you think about that case, you think he's the lead, right? Because he does like everything, right? So again, the lead, it doesn't necessarily mean you're like doing the most, but I wonder, you could be right about that. I've never actually bothered to look it up, right? But I wonder if like technically Cheney would be the lead. That's possible. That's possible. Huh. So again, in that case sense, it doesn't really matter because it's like you can still act like the lead even if you're not technically the lead, right? That's a perfect example of what we've seen for Casey, because Cheney doesn't do a whole lot with the witnesses. Now he comes out swinging in the motion for a directed verdict, but he only handled a handful of witnesses, right? For having said that, he did hit it. He brought it on home with the medical examiners and the forensic anthropologists, but there were like, I don't know, a billion, it seemed like, witnesses before them, and Mr. Baez took almost all of them. It was insane. So.
Next week, or even.
Oh, okay.
This week, if we
Interesting.
Get her and she's available on Thursday, I'd do the afternoon on Thursday, okay, to have this in-camera hearing, if she's available. Correct. And then I'm just saying that as a potential date that you can throw out for her. I should not be in trial. We can have this hearing. I don't think that would take that long. Then we'll have April 19th, 1 p.m. Here's the motion.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes, thank you.
Anything else? Are they done? Okay. Well, what is the rest of this? Wow. Okay, they're done. All right, next one. We have one more to go, one more short one to go, and then that will be it for this one. And then, because next time we'll be picking up with the evidentiary hearing and all the other things, all the other findings. Let me pull that up. Where did it go? Hold on just a sec. Oh, wow. They've got some new pictures of that suspect in the murder of that healthcare CEO, United Healthcare CEO. I'm only saying that because I'm having to go back to my playlist so I can pull up the next hearing. And of course, it's like showing you how YouTube does. It shows you the things that are new on the side or whatever. You guys know what I mean. Anyway, so like I'm looking for this hearing and I just saw that in the corner. Okay, so this is the one right here. Okay. So it's funny because it actually, this one actually starts like the camera cuts on and they're like already into it. So let me see here. They were kind of late with the cameras, and I'll see if I'll put subtitles on for this. Okay.
What was in that communication? We are not going to do that, Judge. We are never going to do that.
What do you want to do?
Judge, I don't know. I mean, I think we have a couple options. One is the court can just assume there's prejudice because this is what I consider a member of the prosecution team not permitting the court to move forward in this matter. And so I think the court would have to.
Doesn't it have to be a factual finding?
I don't believe it does, Judge. At this point,
So they're still arguing over the prejudice.
If a member of the prosecution team, which the ATF is, if they did a significant amount of investigation, they ran wiretaps, they conducted search warrants, they're the ones that conducted the search warrant on Miss Gardner's home in Washington State where they seized the device that issue in the first place. They were the ones that emailed the iMessages around to the law enforcement. So I think that you can hold it against them and make an adverse finding that is prejudicial, and that whatever Miss Butler reviewed is prejudicial. And I think the court should make that finding that they're not willing to permit the court to move forward in the way that the court thought was appropriate on Monday, and that the defense agreed and were ready to proceed today. And as the court knows, we tried yesterday after the hearing to submit written interrogatories by email, and the ATF position was the same on that. And again, nothing against Mr. Willett. He's been responsive, he's been cooperative, but he, as a member of the United States government, is following the policy of his agency. And it seems like that policy is written in stone, and they are not going to back off on that. We can, and that's, I think, where we are.
So the defense objection is to another state actor, quote unquote, ATF's attorney being able to review the answers prior to Ms. Butler providing it to the defense. That's where the objection is.
Yes, sir.
Can I ask you like a hypothetical question? Like if that is her lawyer, what has prevented her from talking or providing that information some other time? So where is the harm in that? That they have their own attorney-client privilege.
So, Judge, I don't think he has an attorney-client privilege with Ms. Butler because his client's agency is not any specific employee. My
understanding too is that they have the federal government has an interest in future investigation.
Oh, sorry I'm getting the spinning wheel. Anyway, are you guys there? Yeah, I got the spinning wheel. So, did they catch him yet? Not to my knowledge. I didn't go, I didn't, all I saw was, it was like new photos. That's all I saw. And so I have no idea. But I'm sure that I would get something on my phone if they caught him. I don't think they've caught him. They just have some new pictures. In other words, they're new pictures, not like someone just took a picture of him. My guess is that they're pictures that just are new to us, right? Like, in other words, they hadn't come out into the public yet. That's my thought. Not like a picture that was taken today, but like, so I'm surprised they don't have them already, but yeah. So, I'll back it up a second since this cut out for a minute, essentially.
Any specific employee?
They have it, but my understanding of TUI is that the federal government has an interest in protecting future investigations, that if you review the answer so that it would not disclose anything related to that. I think that's why I may be wrong, Mr. Woodlook can correct me, but I think that's part of the reason that they require the questions ahead of time to give time to object. Right? I mean.
So you're not wrong. We don't have to have the question ahead of time. We just need to know the topics and what they're expected to testify about. And we get that approved by ahead of time by the U.S. Attorney's Office. And so when Ms. Butler came for her death, it was already approved by the U.S. Attorney's Office of what she was going to be allowed to testify to. And so I think in the alternate round, Mr. Curry suggested through the email interrogatory, he did provide questions, and the questions appear to fall within scope, but my problem is I don't know if the answers would go outside the scope. And so it's been, it's offered yesterday, whether or not a different attorney, other than myself, maybe a U.S. Attorney's Office, a member could review the email. And I don't know how they feel about that. I have not been able to get them on the phone, but if we wanted to go back to in-court testimony or in-camera testimony, I think there's a better chance of having a U.S. Attorney's Office member appear in camera instead of myself.
Like an AUSA from the civil unit?
Yes,
Someone that would normally handle like a TUI?
Yes, sir. Although I don't know the likelihood that they would agree to reviewing the email. As when I spoke to them about that yesterday, they had mentioned that they had never heard such a thing before. But I believe that they would be willing, given time, to provide civil AUSA to come to court.
Why is the court a preferred method for the federal government?
I don't know. I think it just struck everybody as unusual to have them review an email. It's not testimony, it's not being sworn to. It's just a communication informal, which is, I think, is unusual on their part. They're not used to seeing that. So I don't know if they would agree to doing that. I haven't been able to ask it. I think it on the phone this morning, but I don't know if they would agree to that. But I believe that they are accustomed.
We hear about that. The TUI process can be difficult. That's what we're hearing here. That sounds like it's being difficult.
To provide an AUSA to show up to the court before testimony.
Yeah. All right.
Okay. When do you anticipate an answer?
It could be very quickly if I just get them on the phone. And so I tried calling one time this morning, I left a message, I have not heard back yet. So I could have an answer today. I can step out right now and try to do a phone call if you would like.
Sure. Would it be would you agree to someone from the Jacksonville office, or you want to do someplace else?
I think we need it from someplace else. I also, my experience, limited, albeit with taintings in federal court, is that the federal judge actually issues an order with the taint protocol. So that the people that are assigned, because I think that's what they're trying, the proposed solution is that they're going to provide an attorney that essentially can be a filter attorney and not disclose what was said to any members of the prosecution team. Again, this court has no authority over an AUSA to give any order.
No.
And so that would, and that's my problem, is that this court, again, not our problem, it was the state that brought the federal government into this, right, by the ATF, the Secret Service,
yeah,
and
I know.
other people that
Right.
jumped on board, and now we have a mess. And this
Yeah,
court has no
yeah.
authority to order that.
Yeah, and
AUSA
why the fuck did they?
civil attorney, whoever it is, say you can't disclose this to anyone, which would be at
Not at
minimum
all
what we would want.
agencies.
And so
Is
that's
there, let me ask Mr. Woodruff, for example, like when the state wants to gather, like, let's say we're bringing a inmate from the federal government, there are all these procedures. Is there anything that you can think of, like there's a letter, it's signed off by the marshals, there's federal validity to it, therefore binding on the Federal Bureau of Prisons. Is there anything that you can think of that we could institute? Because Mr. Crody is right, I don't have any jurisdiction or power to, I can ask. There's nothing that can be done if it's violated. Is there anything that you can think of? We're thinking of these procedures, however, it needs to have some teeth in it.
And I apologize, I'm not familiar with that, so I can't think of a tool on the federal side to serve that purpose. The only thing I can offer up is, I know Mr. Brady's concern is ATF has been involved in this investigative stage. I only became involved in this when Ms. Butler was subpoenaed by the defense for deposition. Other than that, I had no involvement beforehand. I've only come into involvement for two reasons: for depo, also when she was subpoenaed, then for the hearing on March 7th, and also subpoenaed for the hearing on April 11th. Other than that, I have no involvement. As an officer of the court, I would give my assurance if you would, Mr. Brody would like to proceed with me serving as that purpose of viewing Ms. Butler's answers to the email. And I would give my, promise or agreement, or as also the court, I would ensure you, I would not disclose her answers to anybody on the prosecution team or anybody else inside ATF. And I'm held liable for that, as you can report me to the bar, if I have violated that agreement.
Okay. And what's your objection to him, that he's too intimately involved at this point?
he needs to go to term for the ATF agents and employees that work.
Well, what about AOC and the civil unit?
Judge, I have talked to the rest of our defense team and research it, but I think it comes down to exactly what Ron pointed out, was that they can, if their supervisor says, tell me what's in that email, right? They're gonna have to tell the supervisor, because your order is not enforceable. And again, this is not that I think Mr. Woodland is not a true professional he is, right? This is, we're talking about the most sacred privileges of privileges. We're talking about my client who's facing death penalty. And I can't just roll over and agree that we're gonna have a gentleman's handshake that he's gonna do this the right way. That happened 15 months ago in a courtroom in this courthouse with different attorneys of state, and they made a handshake agreement that they were gonna have a team and they were gonna do it right. And now we know how that worked. And so I hope the court understands that there's a lot of trepidation from the defense side that we're gonna have an agreement that this is gonna be done right. I mean, without, and frankly, that's been the concern, is that we're dealing with the attorney-client privilege, and we're making handshake agreements with no orders and no cheat. And that is not the way in this type of case that, at least right now, I'm secure that I can agree to business.
I understand. I'm not faulting you at all for objecting, okay? But I've got to find a path forward. I've got to find one. I'm trying to respect your request at handling these motions in a timely manner, but we have to somehow find some path forward. And I understand you got to object. I'm not saying that you should not make all reasonable objections. However, thinking of your position, I've got to find a path forward, so that you can, not necessarily even me, you have filed a motion before this court. Portions I understand completely, and other ones I find to be vague. And so vague that I can't, I've got to be able to make a ruling. I've got to make, and I disagree with you. That's how I got myself in this position where we were talking about this in December, and now we're in April, because I thought an agreement that there was prejudice. I was assuming that things that the state of Florida indicated were evidence would automatically be agreed to be prejudiced, and then the decision was either attorney-client privilege or not, and then I would move forward into access, and then second, the other parts of the analysis, right? So I don't think that at this point in time, I'm not inclined to just assume anything. I think it needs to be based on the actual evidence.
And Your Honor, the agreement I'm talking is not the one in this courtroom. It was.
No, I'm not saying that. I'm talking about what happened in this courtroom. That's why we're in April instead of December when this was brought to my attention, because it was an agreement. I thought an agreement about prejudice. Then I get a motion for clarification where I realize that there is no agreement and I need to make those findings. And so I don't think that I want to speak for the state, that they have made in their pleadings and papers that they're not going to just roll over related to prejudice.
Your Honor, I think our position from the defense team is this is not a court problem. This is not a defense problem. This is a state problem.
I agree.
The court was clear on Monday that she wants the answers to that question, at least the content question. We can debate with the media as to whether or not the identity of the client and the dates are privileged based on the counsel's representations here today. I'm not going to look at those cases, but what the court was clear on Monday is the court thinks that the defense and the court should have access to the content witness public review. That was crystal clear. So now it's a state problem as to how to make that happen. And that's our position.
Well, the problem, and Mr. Woodland wants to be present for the answers. That's the problem.
And we are not going to agree to that.
And this problem would persist through a deposition. So there's just no way. At this point, I don't see any way without.
So the problem, the thing that they're talking about is, so the dude that was on Zoom or whatever, that dude that was like, how did he say it? What he was kind of saying is like, what they're arguing over here is like, how involved is that dude? And this has to do with the TUI process, because they're talking about the TUI process. And then this dude is like with the feds talking about how to get stuff for the TUI process, and they need more details, right? Well, then the problem is, it's like, well, the problem is if it's attorney-client privilege again, right? So then it's like the dude who's like assisting with the TUI process, now he's privy to this information. So what he was kind of saying was like, I don't remember exactly how he said it, but it seemed kind of like vague, in my opinion. It wasn't very clear. And so what that happened was the state was like, yeah, we're fine going ahead and letting him do whatever it is that he's doing. And the defense is so that whatever his name was, let me back it up a second. It's this dude's name. Why are we not backing up? Hold on.
Well, the problem, and Mr. Woodliff wants to be present.
Mr. Woodliff. Mr. Woodliff is the dude on Zoom who's involved in getting the TUI process, doing the TUI process. And the state is fine using him or letting him, or sorry, they want him to be present. And the defense is not. And that's what they're arguing over. And it's going to slow everything down because he's assisting with the TUI process.
Answers. That's the problem.
And we are not going to agree to that.
And this problem would persist through a deposition. So there's just no way, at this point, I don't see any way without some agreement by the federal government. And if the federal government doesn't want to have the witness respond by email, I will make myself available. I'll make court time available. So I'm going to give you all time to try to resolve it, how we can get it accomplished. Understanding, I guess, where we're at. I sitting here, I can't think of anything, but I can't think of anything at this point in time that we can do right now. Maybe you all can brainstorm some things, think about what your position is related to, like, you don't want to expose any more information, but is there a way to accomplish what is being asked so you can identify the information so that we can move forward? If it's a different office with the federal government, it's a different lawyer, it's a different jurisdiction.
So remember,
I'm not hugely familiar with the Taint. I don't know how the federal.
Remember, that's going to be all different because they've got the Secret Service, they've got the ATF, you know, I think FBI as well.
Judges do it. It is generally from a different jurisdiction, so I understand. So if there's some mechanism that the state can come up with to get the information over.
And that was the subject of discussion between myself, Mr. Curry, and Mr. Woodruff, late into the evening hours last night. And the state
Still no.
Well, the avenues that we have suggested are exactly what Mr. Woodruff said, which would be having somebody as an attorney to Ms. Butler present during her testimony. She has the right, I suppose, have counsel present to make sure that her interests are protected when she's testifying about her actions within the scope of her employment.
Miss Butler is on the
discussion was to proceed with the first portion of the questions or interrogatories posed by the defense, and Ms. Butler could answer them to the best of her ability regarding the date and time, recipient and or sender, number of lines. We know from her deposition is one message. She says it's a message on X date.
Oh, right. Okay. So here's where this is related to the evidentiary hearing. Okay. I know. Here's the deal. Here's why this matters. Because, so I usually with the TUI process, what we're talking about is oftentimes getting documents from the FBI. Okay. So the TUI process is whenever you're needing to involve any branch of the government. That's why it's the more branches, the more you have to do it, right? Any branch of the government that's as a third party, that they're not already a party to the case, okay? And what I mean by that is things like subpoenas, okay? So, like, for example, if you need documents from the FBI, that's usually what you're talking about, like subpoenaing, right? However, the thing that you have to remember is that you subpoena witnesses. That's why I thought when they were talking about this, I thought they were talking about documents that from that for the TUI process. The reason this is really this needs to be happening right away, and the reason this is a big issue is because they can't move forward until they've handled this whole problem with the attorney-client privilege, and they can't solve that until they have an evidentiary hearing. And this is where it gets. Oh, this is why this is a mess, because they have, in order to have the evidentiary hearing, they need the witnesses that can testify. And who are those witnesses? At least one of them is from a government agency, the Secret Service, Miss Butler. At least one. I mean, there's probably others, but they've also got the ATF. They've got the ATF agent, and then they've got the Secret Service, Miss Butler. So they can't move forward with this, with anything of this until they solve these issues. So this is where it gets, so it all comes down to this TUI process, right? So that they can all have this evidentiary hearing, because the people that they need to testify are from government agencies, because the state brought in all these other government agencies, and now it's all complicated. That's why this matters. I was thinking this was like for discovery. No. That's so that they can even get on with the hearing. Wow.
That's
crazy.
2 lines, 2 sentences. Perhaps that could help narrow it down.
Because they need that.
What do you think about that?
They need testimony. You subpoena witnesses. That's
what did she actually see? I mean, and I don't know that she's going to remember the date, but I have no problem proceeding that way. If the court wants to start that way, I have no.
Why don't you all proceed that way of record? You don't have any problem with him being present for that portion.
No.
Mr. Woodruff. Could Ms. Butler be available to, just since we don't know what the answers are to that, just get those preliminary questions answered today?
Yes, sir. Yes, sir.
Or would you be open to doing it by email? Or you want it to be a record?
I'm sorry, who are you asking?
Mr. Woodruff.
Oh, yes, sir. No objection.
Why don't we do that?
On record or by email?
Email. He said he wanted to do that, and then we would know, like, we're speculating when she does know or she doesn't know, so let's get the answers to those. And then how about I check back in on Monday? And then I will see what y'all are doing to try to resolve the issue. If, maybe the U.S. Attorney's Office is more familiar with this and they can offer some assurances. Has either side spoken to the U.S. Attorney's Office?
No, Your Honor, because this was one of the things that we just sort of came up with last night. I know Mr. LeBeau obviously.
Oh my God, look at this mess. No, this just came up last night. Dude, this is, okay.
I'm happy to get with Mr. LeBeau and Mr. Curry again after today's hearing and see if we can get in contact with somebody, see if they can offer any guidance or suggestions on how to make this happen.
Look at her, look at Judge Kite's face. Is she trying not to laugh or trying not to scream? Probably both. Because this prosecutor, the fuck, you're not even doing your job. Oh, okay. Wow, look at that. Wait, let me back that up. Watch Judge Kite. Watch Judge Kite, guys. Oh, wow.
How to make this happen.
Wow.
I don't know how to resolve the lack of jurisdiction I have. And I'm just, it is what it is. So if there's any, Ms. Stifler, do you know what I'm referring to? Like when you're bringing in a witness for the state of Florida, the federal government has a system or a set of documents that are filed both in state court and in federal court, or with the Bureau of Prisons. I don't know if there's like a, we have to petition, the state would have to petition that. And then if there's something that this court could do to ensure that whatever parameters are set out by the parties is enforced through the federal government, then, so see if there's that possibility that can hopefully assure that if it's not followed or whoever might volunteer to be a part of the case, that it's not just a volunteer that would actually be binding. I don't know if they'd be willing to do that if they're not the agency representing the witness, but.
And Judge, from our perspective, we do think that we can and should proceed on 19, regardless of whether or not this specific issue is involved. There are plenty of other aspects that need to be addressed.
On your bond motion?
No, well, I thought the court needed to resolve this qualification before the court can get bond.
I agree.
So I've spoken to Mr. Baez and Professor Sullivan, and all of us are going to be ready to go on the 19th, and we do not think that this issue should stop the 19th. Right? And so we would still like to keep that date.
I'll hear you. Okay.
Thank you.
From your perspective, do you think it needs to be continued after that date for more information or no?
Depends where we are on this issue on that date. But I think.
Everything hinges on getting this resolved with the attorney-client privilege, and if you're going to have to disqualify the prosecutor or they can't really move forward at all until you get this sorted.
It is my.
I just make it more difficult when you've got all these government agencies.
That will be 4 hours that the court set aside, and 19 will be sufficient for the motion outside of this issue. Maybe we'll have this issue resolved by the 19th, maybe we won't, maybe the court will decide it. I need to know.
I agree, Mr. Brody.
All right, let's push forward. Do you want to come back on the 15th, or do you want to just leave it on? And I can just pass it to the 19th.
I would prefer to just pass it to the 19th.
Agreed.
And communicate with chambers if we need before that.
April 19th, what did I say, 9 a.m.?
1 to 5.
1 to 5. April 19th, 1 p.m. to 5 p.m. Hearing motion.
That is,
Thank you all for being here on short notice. I appreciate it. Okay, court's in recess.
Yeah. I'm trying to remember real quick. Hold on. I'm trying to remember. That one might be in camera. What was the date? Hold on, let me just try to remember what the date was of the next of the big evidentiary hearing, because it'll be the next thing to watch. Let me just do a quick little check. I think I already said the date, but I've mentioned so many different dates. Like tonight that I can't, it's hard to keep them all straight. So let me just see. So the big, where is it? Okay. So this is the big evidentiary hearing. Okay, so that is from April 18th. So that's what they were just talking about, or they were saying the 19th anyway, 18th or 19th. So that is the next hearing. So, and the next document is, where did I pull that up? The next document will be, did I say this was April 18th? So we have an April 16th document, court filing. Okay. So we're going to have, so next time this hearing is going to be long. So what we'll do next time, we'll have one document and then we'll have one hearing. So we'll cover the, what is it? The motion for in-camera inspection. And then we will cover the, let me take this banner down. Then we will cover the evidentiary hearing from April 18th. And that will be the next one. But as you guys probably know, I was initially today was going to be Casey Anthony. I didn't have everything ready for that. So that's why I moved that for tomorrow and did this today. So tomorrow will be the Casey Anthony episode, the one, the state rests or case in chief. So that will be what is next. So, okay. It'll be interesting to see what happens as they go along with all this stuff. But that's the end of this hearing. So they've had, those were the three back-to-back short ones, as I had mentioned in the description. And then we'll have that big evidentiary hearing next time. So thanks guys for watching. Thanks for being a squirrel, and I'll see y'all next time.